Balance to matter relates to selection and appointment of a handicapped person. 2021 matter. So my prayer is that matter will be taken up on 19th of March.
19th of March.
Or any other date of the next week.
All right, 19.
May I please, your lordship? Sir, I beg to mention item number 11 of today's list, lordship.
Yes.
Lordship, may I kindly pass over for the today, lordship. I've entered very recently into the matter on behalf of AIDC.
Item 11.
11, lordship. I've informed the other side. Sorry.
Item 11.
Yes, lord. Any date, lordship, may.
The 2015 matter.
Lordship, I've recently entered because the council has changed for the AIDC, lordship. So, lordship will give me any other date.
Who's for the petitioner?
I'm
You wait, let the matter be called up. Let us see.
Lordship.
Let us see.
Lordship.
What is the issue about?
Issue about the petitioner serving as a company, joined as a company secretary. She has reached the highest level of senior company secretary post. Now she is claiming for creation of a post of general manager, which is ex-cadre, not the cadre she is serving in. So that is the prayer.
See, let the matter be called up.
Lordship. Applied.
May I please the lordship, my lord? I beg to mention item number 10 of today's list. I have yesterday given an adjournment slip, my lord.
15 matter, no adjournment.
My senior is out of
2015
station.
matter.
No, but letter matter is on 28th month.
No. 15 matter, no adjournment.
Even my senior didn't come to court. Even
Can't be
even
helped.
the-
This is the 2015 matter.
I understand, but he gave his consent yesterday.
No, you can't give a consent for a 2015 matter. 10 years.
They requested.
10 years.
But I understand. One request.
1 week 20th, on the 20th, my lord.
Why? It may not be convenient for the court. 20th, we already have a board fee.
On 18, in 18, 19.
What? You have misplaced the file.
No, my lord. My senior is out of station, my lord. That's why, my lord.
Senior is out of station. You are competent enough to address the court. We'll give you the second file if required. But no adjournment. 2015-14 matters, no adjournment. How can there be an adjournment? With what? With what reasoning will you pray for an adjournment for 2015 matter? Tell us. Either this has become infractuous or the petitioner is not interested to pursue. 15 matter, 14 matter, 13 matter, how can there be an adjournment? Wait, let us see. Yes.
May I please, your lordship? I would beg to mention item number 13, lordship.
Hmm.
As we have informed the petitioners, but some of them are posted outside state. So till now, we cannot file the reply, lordship.
2016
16
matters.
matters, I know, lordship.
We'll see.
Let them,
No adjournment. 16.
please, lordship.
May I please, your lordship? Lordship, in this matter.
May I please, Your Lordship? Sir, I pray for listing of a contempt matter.
Over?
Contempt matter. The matter was last listed on 25/11/2024. Already the petitioner is in hospital matter. Already he has not received it. So Lordship kindly.
19.
May I please? I beg to mention item number 6.
6.
Lordship.
Yes.
Then the
File.
file.
Then what remains here? We close it.
My lord.
Permit you to go and appear
My lord.
Huh?
My lord.
in the heard Mr.
M. Rahman.
M. Rahman, learned counsel for the file to now. I don't know. Just 1 minute. All right.
Let him appear, my
We'll call this up as the first item. Just wait. Just wait. We'll call it up as the first item.
My lord.
Just now. Yes.
My lord.
Mentions anymore.
My lord, I beg to mention item number 12. What happened in this case, I have just newly engaged counsel. I have just
Another 15 matter, no adjournment.
only 1 week. I have to prepare, Lordship. I have
We'll
just
see. We'll see. We'll see if there is a genuine difficulty. We'll accommodate, but not for the asking. We'll have to go through the file and find out if there anything survives from 2015 to
Lordship, I
2010.
have just filed the Wakalatnama, Lordship.
May file. Why did you accept a 2015 matter today?
But earlier,
Not for us
my lord
question,
was
but we are
earlier
thinking
the
aloud.
earlier my lord was there. Lord.
We'll see about that.
All right.
No adjournment. Heard Mr. M. Rahman and Mr.
B Sharma.
B. Sharma, APP. This is a second bail application.
Lordship.
The anticipatory bail application has been filed for the second time in connection with Hula PS case number 38 of 2024 under section 2 the IPC. The earlier bail petition stood rejected by an order of this court by the order dated
31/8/2024. Page 25.
31/8/2024 in AB 1401 of 2024. Stop. Subsequent thereto, the present bail application has been filed. Stop. There are today, when the matter is called up, it is submitted at the bar that the investigations have been completed and charge sheet has, in the meantime, has been
Well,
filed. By the
charge
charge
sheet-
sheet number
13/2025,
13/2025,
dated 31/1.
dated 31/1/2025.
Well,
Stop. In that view of the matter, the counsel for the petitioner submits that the petitioner be permitted to approach the competent court before which the charge sheet has been filed.
Right.
Accordingly, this AB petition stands closed, permitting the petitioner to approach the competent court, court of competent jurisdiction before which the charge sheet has been filed by the investigating authority. Stop. Needless to say that when the petitioner approaches the concerned court, that court will examine the material and pass appropriate orders by keeping in view the guideline rendered by the apex court in Siddharth versus State
obliged.
disposed.
Maybe, Lordship, Mr. Kotak is out of station, so maybe matter may be taken next week, my Lordship.
Next week,
Next week, any date, my Lordship.
all right. 20,
Hearing is otherwise concluded, Lordship, on the last occasion.
20, or we'll have it on 19th. 19th.
Lordship.
At the request of Mr. Antu, submits that arguing counsel is out of station. It has been prepared to be listed on 19th. Mr. Sharma appears for the response.
Obliged, my Lordship.
Yes.
The matters are ready for hearing.
Lordship,
What is the issue here?
Lordship, the issue is with regard to Lordship selection and appointment to the post of Gaon Pradhan, Lordship,
Now,
in South Salmara district. Lordship. South Salmara,
what
Mankasa.
is your claim?
Lordship, my claim is, Lordship, initially I was selected by horizontal, Lordship. They have replaced my name by the with response number 7. Thereafter, Lordship, I filed a complaint. And after complaint, Lordship, there is a CM's vigilant case, and in the CM's vigilant case, Lordship, whatever
CM vigilance case against whom?
against all the members of the selection committee, and all the 4 members of the selection committee have been arrested in this case. And charge sheet has been laid. 4 charge sheet have been filed.
Then what happens to the respondent 7?
Because of the stay order, Lordship, no one has been appointed. Lordship. And Lordship, on earlier occasion, Lordship, the record was produced. And Lordship, in the record, Lordship, after perusal of the record, this honorable court by earlier order, Lordship, I have noted down, Lordship, that Horizontal was issued on 14/6/2018. So the select list which was published on 19th, Lordship, that was the last horizontal. So there was no any office
note on any state lordship, wherein lordship the corrigendum was issued. This honorable court has asked the department whether there was any note sheet, any decision, how this corrigendum was issued. And this honorable court lordship had earlier orders lordship on 28/10/2022 directed the department to produce the record. Then 12/12/2022 another order was passed by the honorable court. Why appropriate order should not be passed for interfering with the selection illegally made by the selection committee, which had resulted in charge sheet being filed against the committee members. Thereafter, another order was passed on 19/12/2022. Commissioner Lower Assam Division to
So
propose as to
what
why
are your grounds for challenge here?
challenge lordship. Initially, lordship, I was selected. Thereafter, by corrigendum lordship, they replaced my name.
And what do the records say? Why the name was replaced?
Lordship, record is not available with me at present, Lordship.
What does your affidavit say?
Not filed, Lordship.
Not filed.
Not filed.
Affidavit not filed. Who is respondent one? Revenue and Disaster Management, they filed. Who conducted the selection?
The Deputy Commissioner. Deputy Commissioner, Lordship. Lordship,
Oh, there is a charge sheet filed against Deputy Commissioner also.
Yes.
yes, Lordship. Then, Lordship, yes, Lordship. Charge sheet submitted against the Deputy.
Such sheet was filed with regard to illegal gratification. They have taken 5 to 7 lakhs from each of the Gaon Kotas before selecting the candidate. That was the allegation, and that has been proved.
No, but that is the charge sheet.
Yes.
It has to be proved. If it is proved that this selection was conducted by accepting illegal gratification, then of course it is a ground to set aside. But till it is proved, can this be a ground to interfere with the selection?
That is all. That is why lordship, this honorable court has asked what is the stage of the trial in the CM's.
What is the stage on the trial, Mr. Counsel?
That was asked by the honorable court on repeated.
Mr. Goswami, what is the trial stage?
Lordship, from the earlier instruction, Lordship, it appears that the vigilance base case number has been charge sheeted against the all the seizure list. The status of the trial of the special case number 17/2021. It is, Lordship, fixed for part of copies. It is a accused for copy, Lordship. Furnishing the copy to the accused person.
When is the next date?
Lordship, next date at that it is 29/3/2025, Lordship.
So essentially, it has not even progressed.
Lordship,
Now, besides that, what are your grounds?
That is my only ground. Lordship. I challenged the selection because it was initially me who was selected. Thereafter, they manipulated the records and just published the corrigendum on the same day.
No affidavit filed.
Without any note sheet, any
Lordship,
records.
Where are the records? CM Vigilance.
no, CM vigilance, Lordship, record is there, Lordship.
Yes.
They this is
No,
Lordship,
in the face of the contention that there was manipulation in the selection, what is your stand
Lordship,
as the DC?
there is the manipulation.
You
Lordship,
admit.
no, Lordship, that is why Lordship needs the record, Lordship.
Huh?
Needs the I have to peruse the record, Lordship.
So who's holding you?
Yes,
Go and
Lordship.
peruse it.
No, Lordship, at the same time, Lordship, I have to file an affidavit, Lordship, on this regard, Lordship.
No, but first your records must be available with you. Are they available with you?
Lordship, from last case, no?
Who is the appellate authority here?
Lordship,
Appellate
Deputy
authority
Commissioner.
now is the director of
Yes.
Director of Land Records. So let the appellate authority decide on this issue by examining the
Alternative remedy is there.
Yes. But then how will the director decide in the absence of the record?
Lordship, my senior friend Sutia Lordship at once produced the record, and that was perused by Honorable Justice A.D. Chaudhary. Lordship.
Lordship,
And
kindly fix the
I will-
matter. Lordship, what I'm saying, kindly fix the matter after 3 weeks. Lordship, I will produce the record along with the affidavit. Lordship.
You produce the records before the appellate authority, 3 weeks, within
Lordship,
3 weeks, they will be able to
let-
dispose of.
Lordship.
But
It
provided
may,
the records are produced,
Lordship.
hmm? No, but the records are with the vigilance.
yes.
Somebody will have to get the record. You get your instructions and inform us at 2 p.m.
Regarding
Director Land Records. Whether a direction permitting them to call for the records would be sufficient to get the records, examine and pass orders.
earlier order, no, to record to appear for this question.
Then we can pass. Otherwise, notwithstanding the direction, if the records are not handed over,
एक इसको टेंशन for this person.
Mr. Goswami, you also seek instructions
Whether
as to the status of the records. Where are they?
Lordship, it will give.
They are here.
Lordship, I got it. Lordship.
Huh?
Yes, Lordship, I got it.
Huh?
I got it. The record, Lordship. Record is there.
Then
Record is there.
you examine and tell us at 2 p.m. whether on what grounds his name was changed.
Lordship, one thing, Lordship, they may file an appeal. Lordship, is the alternative remedy is there. We'll produce
We
all
are
the records.
asking you something. Where are the records? Are they with you? Are they with ACB? Are they with the department? Where?
Lordship.
How will the appellate authority decide this issue even if we direct them? Unless the records are available before them.
Lordship. Lordship, in running page number 104, internal page number 3, affidavit filed by the respondent 2, Lordship. Lordship. That হেৰি to চাই লওঁ মাৰ্কশ্বিটটো চাই লওঁ যদি
লিখি দিছো ইয়াত। Just 1 minute.
paragraph 104 paragraph 2 Lordship.
Just 1 minute.
Lordship. নাম কি তেখেতৰ Nurul Islam. Yes, yes, yes.
Yes.
Lordship. Lordship, 104, Lordship. Page number one, running page number 104, internet page number 3 of the affidavit filed with the respondent 2. Paragraph 2.
Yes.
Yes, Lordship. That though the instant writ petition, the petitioner has challenged the selection and appointment of the respondent number 7 as Gaubura of lot number 12 in South Salmora, Mankasar district. Following selection held pursuant to the advertisement dated 19/05/2018, an order dated 9/7/2019 was issued by the Deputy Commissioner, South Salmora, Mankasar. At serial number 12 of the said order, the petitioner was shown to be selected for the post of the Gambura in respect of the lot of number 12. However, by a corrigendum issued on the same date, this is 9/7/2019, the petitioner was replaced by respondent number 7, Nurul Islam Sheikh as the Gambura of lot number 12. As per the said corrigendum, there were some clerical mistake in the names of the selected candidates, such as their father's name, address, etc. Being thus aggrieved, the petitioner has filed this instant petition. Now, Lordship, we have the record and we have the result sheet here. And result sheet shown like this. The marks is there allotted against petitioner and respondent number 7, Lords.
So which is the petitioner 99?
Yes, Lordship. There's a marker, Lordship.
Both are marked. One
Yes,
is first and one is second.
Yes, first and second. First one is the respondent, Lordship, 7, and second one is the petitioner, Lordship.
This is the result sheet, compilation.
Yes, yes, Lordship.
And then what happened?
The respondent obtained the more marks than the petitioner, Lordship.
Where are the marks allotted by these officers? There are 1, 2, 3, 3 officers.
Yes, Lordship.
They have allotted marks. Where are the marking sheets? Is it available?
That was, Lordship.
If your lordship says page 150, this record was produced earlier, lordship. Pursuant to that production of this record, 150 order was passed by the general court. Page 150.
সেইটো দেখাইছিলে নেকি?
This is only the compilation sheet.
Yes, Lordship.
No, but here there doesn't appear to be any mistake. First and second is clearly identified.
Yes, Lordship. But when the result was declared, Lordship, it was declared the name of the petitioner.
No,
First.
no. See.
After that, it was
Come to page 103, 104 of your affidavit, para 2.
yes, Lordship.
Para 2. You just pointed out,
Yes.
just a few minutes back.
Yes, Lordship. 104.
104 para 2.
Yes, Lordship.
You say that initially petitioner was declared to be the
His name was declared as a
Declared.
selected candidate, Lordship. But
subsequently because
one
of
corrigendum was issued, Lordship.
why was it issued?
Because, Lordship, due to the mistake, some clerical mistake, Lordship.
Where is that office note to say that there is a clerical mistake?
Yes.
In view of your compilation,
Yes.
where it is clearly identified who's first and who's second,
Yes, Lordship.
where is that office note? There has to be somebody giving some indication that, sorry, we had wrongly declared the result.
Right.
Is it available in your file?
Exactly.
You check up and tell us after a while.
Lordship. I will check.
I have a pattern matter in court number 12. Let me kindly accommodate me.
We'll call up in a while. You request your colleague to be present when the matter is there. And this is also part heard. No, it's not part heard.
Wait for your. He has passed the, he has filed the affidavit, additional affidavit along with the contract agreement. Nothing new in it, file. Plus 47, your lordship, may kindly see. একটু দেখাবো কিনা? Page 150 of the affidavit. Internal page 52.
64.7 loss. 47 is 64.7.
64.7.
60, it is in loss 150, page 150.
47.
64.7. 150 loss.
Hmm.
Last line, my lord, may kindly pay.
Last line.
The provisions of clause 63, 64 to the general condition of contract will be, next page, lordship.
Subject to the provision of the affidavit.
Yes.
Next page, lordship.
applicable only for settlement of claims or dispute between the parties. Amount is more than or equal 20% less, and the value of the contract when the claim is disputed, and the value more than 20% value of the contract provisions is clause 1. Other relevant clause of general condition of contract will not be applicable for arbitration and will not be remedy for the settlement of a such dispute loss. Here our ground is that the claim is more than 20% loss. This is the condition of the GCC lawsuit. And accordingly, we have written to the contractor to lawsuit or reduce the amount lawsuit. That is also there in page 59 lawsuit.
So this is that same 20% below 20%. So we had passed an order that it is to be decided by the arbitrator.
Yes,
That part. Now, that part already I have indicated. This here also it is more eligible, but otherwise, I have downloaded it. They have sent it from to WhatsApp. That's why it is not clear. That portion is clear also.
He may
That
say my,
document.
this is.
That document is clear also.
Hard. MS Soikiel.
A salient point, my lord, is for your lordship convenient, my lord.
Yes.
Decision also.
This is for appointment of an arbiter.
Arbitrator. also.
Appointment arbitrator.
The petitioner,
My lord may just indicate that part will be decided by the arbitrator. That
mm,
you said?
there are facts, can you say? The respondent, you have filed your affidavits.
Lord, sir, we have filed. This is our as per my lord's direction. That was filed, Lord, sir.
No, not the additional affidavit. Earlier,
Additional affidavit along with additional affidavit. Additional affidavit that already my lord have perused. As per lordship's last direction, we have filed.
the respondents filed their affidavit contesting the case of the petition, stating that the claim of the petitioner is not applicable in view of clause 64.
64.7, Lord.
64.7 of the agreement. The council could respond have pointed out that there is a specific clause which prohibits reference to arbitration in the event the value of the contract is the claim of the contractor is more than 20% of the contract value. Contract value. So, the counsel for the petitioner, on the other hand, disputes the contentions raised. She has submitted that this court had earlier considered this issue and had appropriately decided the matter in WPC number 1076 of 2024 within bracket Union of India versus MS GSR Ventures Private Limited. So, counsel for the parties have been heard. Things of the court have been carefully perused. The agreement executed by and between the petitioner has already been perused. By order dated 31/8/2024 passed in WPC number 1076 of 2024. This court had earlier held that the question of jurisdiction of the arbitral tribunal can be decided by the tribunal itself. Referring to the judgments rendered by the apex court, this court had held that the question to be examined by the referral court is the existence of an arbitration agreement by and between the parties. Stop. Where there is no dispute as to the existence of an arbitration agreement. All other questions may be referred. All other questions should be dealt with and decided by the arbitrator / the arbitral tribunal. So this view of this court is pursuant to the judgments rendered by the apex court in so and so versus so and so. Stop. This position has been further clarified by the apex court in yet another judgment in SBI General Insurance versus so. Relevant errors of the judgment are expected below. The other question raised by the respondents are that the railways have maintained a curated panel, and even assuming the matter is referable to arbitration, the arbitrators are to be appointed as per the procedure prescribed under the agreement, and an arbitrator within bracket S arbitrators are to be appointed from the curated panel maintained. So, this aspect of the matter has already been decided, and the law is settled in this respect in view of the judgments rendered by the apex court in CORE judgment, and subsequently further clarified by and other subsequent judgments like SBI General Insurance. In that view of the matter, this court is of the considered opinion that the arbitration petition should be allowed. The petitioner has been able to make out a case for issuance of orders for appointment of an arbitrator on the failure of the respondents to appoint an arbitrator when called upon to do so by the notice dated so and so issued by the petitioner earlier. So accordingly, under powers of this court, under section 11 of the Arbitration and Conciliation Act, and read with the notification number 29 May when so did, this court appoints. You want P.K. Mushari?
Yes, ma'am.
As per the list, I pay for as per the list.
As per the list only. His name is there.
His list, his name is there.
For a new list.
As per the list only.
His name is there.
We are only indicating names as per the list. Mr. Justice P.K. Musari, former judge of the Guwahati High Court, is hereby appointed as an arbitrator to arbitrate and decide on the disputes arising by and between the parties. So, the arbitrator will also render appropriate findings on its jurisdiction in the event such a question is raised by the railways. Stop. The appointment of the prospective arbitrator, however, is subject to the written declaration to be furnished by the learned prospective arbitrator in terms of section 12(1) of the Arbitration and Conciliation Act 1996. Stop. A copy of this order be placed by the registry as well as by the parties before Honorable Mr. Justice P.K. Musari, former judge of the Guwahati High Court, and thereafter, the prospective arbitrator, and thereafter, this appointment shall be confirmed upon receipt of a written declaration from the prospective arbitrator, which shall be placed before the court. Let the matter be listed again. When?
After 1 week,
After 1 week,
it is
on 24th. 24th?
24.
It's 24th of March.
Obliged.
Where is the petitioner?
In the Supreme Court also, the association has filed an affidavit which follow that order was passed by the Supreme Court, the GPS. And the individual affidavits were error number 3 of it by the General Secretary of the partial to negotiation with the application and resolution passed on behalf of the union entered into a MOU dated so containing goodwill package scheme with the attendant terms and conditions prepared therein with the appellant for benefit of the workers members for union. I and other office bearers of the union has explained all the members of the union the meaning of the provision of MOU in vernacular and asked all affected 290 members respondents to submit affidavit on the MOU to the individual, which all agreed and submitted their affidavit filed on record in all 290 affidavits.
Why don't you examine his claims, if any,
No, my
and
lord.
finish off the matter?
No, his claim was examined, my lord. Because he cannot go to the main case.
No, do it again.
Yes.
Do it again for the satisfaction, just to see whether he is entitled to some claim and close it.
My lord, as per clause 2 of the MOU, my lord, he is not entitled to because he has to be present, my lord. Because all others, my lord, 20 members also filed, my lord,
No, that's
application for the
right.
CJT.
That's right. You just examine, you revisit these claims again and pass an order, whatever orders are there after examining the report, by giving him some opportunity of hearing or whatever he requires. I mean, it's on a very short issue, because otherwise there'll be the issue opens up. There'll be the question of whether estoppel is applicable, not applicable.
Estoppel, my lord, I have spoken to the judgment, estoppel is always applied, my lord. Claims directly.
In what are these circumstances estoppel will apply? All these issues are there.
My lord,
This court is,
my lord, the
What is-
criminal case is pending, my lord.
court is only of the, court is trying to understand that here is a worker who says he wants some claim, whatever. Is there any other person like similarly situated, like the petitioner?
Yes, my lord.
No,
Well-
any other petitioner who's been denied the claims?
Well, about 20 persons filed a similar petition before the CGIT, and that was also defeated on the ground of estoppel.
All right, we'll hear, then we have heard everything, you will pass orders.
Lordship on the last occasion has directed me, my lord, to produce the quantification as to how much amount he will be entitled to. If Lordship sees from the first page, my lord, September 1989, my lord, he came to be appointed on contractual basis.
That is your claim.
That is my claim. And in the last phase, my lord, I have quantified it, my lord. During his service tenure, my lord, he has received an amount of 6,18,000 total amount. And as per his calculation, my lord, the amount to which he claims to be entitled now stands at, my lord, rupees 1,33,04,013 rupees, 0.25 paisa. This has been taken into account on the assumption, my lord, that had he be in service, my lord, he would have drawn the regular scale of pay. So in the last page, lordship will find, my lord, from April 1994 to August 2008. So that is the regular scale of pay.
The individual
One
affidavit,
decision I will be relying.
individual affidavit, my lord, the petitioner also filed, my lord, there. That central copy is there, my lord, that in the bunch, my lord.
In that decision, lordship may kindly peruse paragraph 18, my lord. That is a constitution-based decision. Yes.
Yes, sir.
In appropriate circumstances, the court can interpret that award for the purpose of making monetary benefit to the debtor.
What is your case on the point of estoppel?
Point of estoppel, my lord, I have not signed any affidavit. I have not signed. Although in that letter, purported letter which they have produced, my lord, I have taken specific instructions from my client. He says that he has not signed any affidavit. He was pressurized at that point of time that he would be given, my lord, that benefit under the golden package scheme. So therefore, he had sought that letter, my lord, to the authorities. But he has not signed any affidavit. And more so, my lord, those interlocutory applications which were, my lord, pending at that point of time, my lord, in those interlocutory applications, those applicants have specifically filed their affidavit. There is nothing on record, my lord, to show that, my lord, he has signed any affidavit. Had he signed any affidavit, my lord, I would have no case, my lord. Lordship is absolutely correct, my lord, in saying so, my lord, that I will be stopped from claiming any further benefit. Because I will be waiving and foregoing my rights under the award. Now, here is a case, my lord, where I am solely, my lord, relying and resting on the award itself. And my lord, that apex court decision which lordship has just now seen, my lord, at paragraph 18, honorable apex court, my lord, is the constitution-based decision, my lord. It has held, my lord, that in appropriate cases, my lord, it is open for the labor court, my lord, to interpret the award for the purpose of, my lord, granting monetary benefits. That works, my lord. Lordship has
Where is the award again?
award, lordship will find, my lord, it starts, my lord, from page 16, my lord, of the writ petition. Page 16. In the conclusion and the operative portion, lordship will find at page 26. In the light of the aforesaid discussion, it is held that there was a dispute between the management of ONGC and its workmen, and the government has rightly referred it for adjudication by this tribunal. So I find the reference maintainable. the management of ONGC in Kasar Project Silchar is not justified in not regularizing the services of the concerned workmen. It is enough to say that they are all members of the union and their interests are well represented by C. So-and-so as president of the union. It is therefore directed that the services of all the concerned workers are to be regularized by the ONGC phase-wise, if not possible at a time, with pay and other allowance paid to regular employees. And even as on today, my lord, this award stands, although it was assailed up to the apex court.
This was filed by the union.
Union. It was filed by the union.
Now, if it was filed by the union,
Yes, my lord.
it is the same union who has also entered into a contract. If you claim to be the member of the union, which was before the labor code, and you are claiming benefit thereunder, and the industrial tribunal has held
Yes, my lord.
that the union can represent the interests of the workers.
Yes, my lord, that aspect of the matter was clarified, my lord, in the order itself. My lord, in the order include during cross-examination. Kindly see, my lord, the cross-examination part, because they had also earlier taken that plea before the learned tribunal below.
Yes. Which part?
Yes, my lord. My lord, lordship will kindly come to page 139, my lord.
Yes.
Page 139, my lord. I'm reading from the, my lord, cross-examination part, my lord, from above. The award passed by the Honorable Industrial Tribunal Guwahati was accepted by us. The dispute in connection with reference case number so-and-so was raised by the management of ONGC, and their workmen represented by General Secretary ONGC Contractual Union Silchar. The ONGC Contractual Union Silchar, Contractual Workers Union Silchar and Barak Valley ONGC Mazdoor Union are different workers union and they were registered separately, but they are not recognized by the ONGC. They had also taken the plea that none of the they took the plea that they did not even recognize any of the union.
Cannot be.
Yes. Now kindly see further, my lord. Recognize, although in the title page of MOU, it has been mentioned that the MOU has been executed by the management of ONGC and three other workers union, but practically it was signed by the General Secretary Contractual Workers Union of ONGC only.
No. Whatever it may be, the penultimate portion of the finding is that this reference is maintainable. Page number 26.
Yes.
Reference is maintainable.
Maintainable.
And Industrial Tribunal also held that they are all members of the union and union can represent the interests of the workers. And if you come to the first page of the award,
yes, my lord,
it shows that there is only one union.
Yes.
ONGC Contractual Workers Union.
Yes, my lord.
Now, if you say that this award is applicable in your case, then it goes without saying that you are a member of this union, contractual workers.
I may be a member of that union, my lord, but the award, my lord, the fruits of the award entails to each and every, my lord, worker.
Correct.
Yes. So the union has espoused the case. The union might have espoused my case, my lord.
Correct.
And my lord helped me in, my lord, getting that award.
No. See, you can't be allowed to blow hot and cold. Union represented you.
Yes.
You had relied upon the union to represent your case and they had filed an order.
Yes.
Now, court says that yes, union is capable of representing.
Yes.
industrial tribunal. That the same union has now got into an agreement. In fact, an affidavit has been filed saying that have explained to the members the meaning of the provisions of the MOU, this and that.
Yes, my lord, I have seen this bunch
Then-
of papers, my lord, which has
then-
just now have been handed over to me. But whether, my lord, this was at all fine in those interlocutory applications, it is completely silent.
No. Whether filed or not filed, we are not on that. If you are a member of the union, which you claim to be, and if you say that the findings of the industrial tribunal in favor of the union are also applicable to you by virtue of you being a member,
Yes, madam.
then unless you produce some
Absolutely,
material
absolutely.
say
Yes. Yes, I got
that
it.
you did not
Yes,
authorize
yes.
the union to get into it,
Yes, yes.
they
Then-
cannot represent you now.
Lordship, then, my lord, I will have to seek instruction because this has been just now produced.
Where is that MOU? Is it here somewhere?
Well, then they have an
MOU is here.
Yes, my lord. Lordship will find it at page 72. Page 72, my lord, of the writ petition.
72.
Yes, my lord. At page 72, Lordship will find, my lord, the workers are represented by 3 unions.
Correct.
Number 1 is the ONGC Contractual Workers Union, my lord, which, my lord, union appears to have, my lord, filed this affidavit, this bunch of papers which had been handed over to me just now. Number 2 is, my lord,
No, this
contractual.
ONGC is the one who had approached the industrial tribunal.
page
Yes.
76, my lord. Your
Yes.
lordship must see page 76.
So if you want the benefit of this, then it means that you belong to the union of contractual workers union, ONGC.
Therefore, my lord,
ONGC contractual workers union.
my lord, yes, my lord, some,
And the affidavit, my lord, that order your lordship see that before the industrial tribunal, 199 page. Page 199 very important, my lord. In our affidavit. Page 199.
Yes.
He had an application, my lord, here. Page 199 affidavit.
199.
Right.
Yeah.
199. It's a E.
Yeah.
The applicant is present along with his learned advocate Jacob.
Hmm.
The OP respondent is written by Kipesh Chakraborty, senior manager, HR, along with Mr. B. Das, learned advocate of representative has submitted return that HWS. Hard both side B. Das, learned advocate of the OP respondent submitted that this case is not at all maintainable. As the matter has already finally decided by the Honorable Supreme Court, and the same is acknowledged by the memorandum of understanding agreed between the parties, and the GPS package adopted on the basis of the MOU by order that 15/3/11 passed by the Honorable Supreme Court in so and so. Thus also added the applicant was absent since long and hence he enlisted absentee in the matter was intimated to applicant through communication dated 12/11/2007. In spite of getting the such communication, the applicant has not taken any step. J.A. learned advocate, on the other hand, assailing the submission of the learned advocate for the respondent took the plea that the applicant has not even received the benefit out of the MOU and GPS package. Even the applicant has been refused the benefit of the aforesaid scheme, and applicant was not allowed to join. As Mr. Kaur, learned advocate paid for reducing evidence on the matter in order to establish his plea, reduce the CSO. Then therefore he did not appeal. Go to tribunal. He failed to substantiate that he was present. That is
I
the
think that
only with regard to the fact, my lord, that whether, my lord, my right have been waived, my lord, by on the strength of this affidavit. If lordship allows me, my lord, I can take the instruction. Because this is on fact and I am taken by surprise, my lord, because this is,
all right, you take your instructions. We can give you one more date. There's no problem on that.
I apologize because I am troubling lordship, my lord. Because
No
these
trouble to
documents
us.
have been a part of their affidavit, my lord. They are giving those documents in piecemeal manner, my lord.
All right, Mr. Sayola, we'll just give him a short date.
Hello?
Mm. When do you want it?
He will kindly grant me 1 week time at least because this man come to
27th,
27.
27th of March. List for further hearing on 27th of March at the request of counsel to the petitioner, who submits that the affidavit produced by respondent number 1, affidavit filed by the union before the apex court was produced in court, and he would like to complete his instructions in that respect. List accordingly on 27th of March.
I'm so grateful.
Where is the respondent side? Look forward to. Yes, Mr. Goswami.
Lordship, regarding the correction, Lordship, there is no office. Regarding the correction,
Regarding
the correction of Lordship, there is no office.
then on what basis are they? Has anyone come to a conclusion that no, it should be number 7? Have you checked the records? You check the records and tell us from the record. The records of the selection.
Yes.
You have to check the records and tell us.
Record is here, Lordship.
If you do not have the complete record, get the complete record.
Lord, I will. I will talk with the concerned officers regarding it.
27th. Matters be listed on 27th March, enabling the in view of the fact that the Learned Government Council is not posted, is not in possession of the complete records for this election, and is unable to submit with regard to any orders or office notes that may have been passed by the authorities concerned, whereby the respondents have issued the corrigendum in favor of the respondent number 7 to be the selected candidate in place of the petitioner. Let the Government Council produce the may complete his instruction, and if required, produce the relevant records before the court on the next date fixed, which is 27th of March. List accordingly. 27th. Yes. Yes.
That I retired from UCO Bank. In banks, there was no pension till 1995. In 1995, in lieu of contributory provident fund, pension was introduced.
Mr. Sharma is late before another court office. Court number 5.
Well, let us hear the petitioner. You inform him. Yes.
So, sir, my lordship, in the year 1995, when the first option came, I did not opt since it was contributory, in lieu of contributory provident fund. Then again, like me in the industry, thousands of people did not opt. So there was another chance of option in the 2010 through a bipartite settlement.
Through a?
2010 through a bipartite settlement between the banks and the trading unions. As per that circular, settlement, the pension circular was issued in UCO Bank where I work. And according to that, a form has to be submitted and a pension cost of 2.8 times has to be given. Now, sir, I opted for that pension. I submitted my pension form on 28th September 2010, well before the last date. Bank also deducted my pension cost to 27,552, which is 2.8 times of revised pay in 2010. Thereafter, bank debited that pension cost, which was kept in suspense account, debiting my account in March 2011 and deposited into the pension fund. In all my salary slips for all these years till my retirement in 2021, it was mentioned that I was a pension optic. I retired in July 2021, and prior to my retirement, my pension papers were submitted. The branch authority where I used to work at that point of time verified my pension application, confirming that I am a pension optic. However, the pension was not granted to me. I waited for 1 year, and thereafter I represented to the general manager HRM from my journal office in August 2022. Getting no response in September, I represented to the managing director and CEO of the bank in September 2022. And after I represented to the MD and CEO, suddenly after 1.5 years, in December 2022, bank's contribution to Provident Fund is credited to my savings account, which is generally credited to savings account when a person is not a pension optic. So I immediately wrote back that I am a pension optic. And when I wrote back, after about another 5 months, the pension cost that was deducted about 13 years, 12 years back, 13 years back in 2010, that is 27,552 was refunded to my account in May 2023, and pension was not given to me. Sir, my lordship.
So the pleadings are complete here.
Yes, sir.
Then we post it for hearing. We'll keep it for hearing. What is your prayer in the writ petition?
I merely asked my pension, my legitimate pension, for my 40 years service, almost 40 years service in bank.
Pension not released.
Yes, sir, Lord.
Why not released?
Your Lordship, that there is a specific condition that before 18th of October 2010, person has to submit the applications. Although the money has been submitted, 27,332, but applications was not submitted. And it has been not reached to the office.
So it was?
It was not reached to the concerned pension office of the head office, Your Lordship. So that is why the name of the writ petitioners has not been qualified for the pension. And he is not the pension optic.
Now, under what provision is that cutoff date set?
Yes, sir. It is in the circular of the head office, Your Lord. That is at page number 280 of my. Until date, no application is being filed before us, Your Lord.
My Lord.
Because there are total 5 numbers of copies.
Yes.
My Lord, I submitted the pension option form in due time. That is why the pension cost was deducted. Number one. Number two, sir, my Lord, that pension cost has been credited to the pension fund. My Lord, thereafter, all my salary slips bears the proof that I am a pension optic, And finally, the branch, when forwarded my pension papers, also confirmed that I am a pensioner. Now, my learned friend says that I have not submitted my pension option and placed before the court that pension option form is this in page number 249 and 250. But I have already submitted in page number 172, 173, the bank's acknowledged pension option form.
No, it is just an attested of signature. There also page number 173, the signature of the bank is appeared, but it is only in regard to the attestation. It is the
No, what papers were not submitted?
it is application, Your Lord.
Page
That
number?
the application that has been attached at the page number 172 of the writ petition was not submitted before us, Your Lord.
So, my lordship, it
Page
bears
number-
the signature of the bank.
How was it required to be submitted?
Yes, it is to the office of the chairman, managing director, executive director, page number 172, general manager, personnel. Because there is an extra cell that has been.
No, this is to be submitted where? To which office?
Your Lordship, it is in the head office, Your Lordship, at Calcutta.
This is to be submitted by the employee
Yes, Your Lordship.
directly,
Direct.
not through the.
Not through the branch. Branch will attest the signatures only. That is appeared at page number 170.
73.
170.
How did you send this? How was this sent?
My lord, circular clearly says that I have to submit to the branch in 5 copies, and branch has to forward 3 copies to administrative office, that is general office.
Which circular says?
My lord, in page 128, that pension circular, who can opt and how.
Yes, which clause?
My lord, I'm sorry. Page number 131, role of the branch and office. A copy of the circular must be displayed, etc., etc. Three copies of all the option forms in the penultimate paragraph in page 131, 3 copies of all the option forms in service employees, retired employees, voluntary retired employees, family of the deceased employees be forwarded to journal office within 7 days from the last date of option in a single law. In page 131.
Yes.
And my lord, even the voucher was clubbed together. 3 persons was pension cost was deducted, and other 2 persons has received the pension. The option forms was sent in a lot. Pension cost was deducted in a lot.
It is to be done by the branch office.
It is not reached, Your Lordship.
Huh?
Not to the branch office, not to the.
No, you see page 130, 131.
Yes, Your Lordship, but it is not been reached to the head office, Your Lord. And in the branch office.
No, if it has not reached, then you inquire at the branch office.
No,
How is
Your
it the
Lordship,
fault of the employee?
Your Lordship, page number 173 is only the attestation of the signatures. But it has been received by the branch, there is no signature.
No, who is for the branch? You find out what is the status of the documents of the petitioner.
Your Lordship, we have inquired, but there is no such documents available in the branch, journal office or the head office. Your Lord. Although
Yes.
he has deposited.
My
But
lord,
there is
it
no
is,
receiving of the branch, Your Lord.
my lord, if it is not available at their end right now, what I can do, sir?
No,
13 years back, I have
what you
submitted.
can do, we don't know. But you are before the court asking for a direction to the authorities to release your pension.
Yeah.
Authorities say that there is no record of your receipt of pension. Now you will have to find out ways and means to show that you had submitted all the papers as required.
I submitted.
What orders do you want from the court? We can't create these documents for you.
My lord, this is a acknowledgement
Is there
by the
any
branch.
where page number?
Page number. Page number 172, 173. This is what I have.
172.
173 is the attestation of the signature. Your Honor. This is I have submitted, and this is the copy provided to me. I am a full-grade employee at that point of time.
173.
Yeah. It bears the attestation of the branch head that I submitted.
No, this is an attestation. It does not show that it is
Received by
It
us.
can, on prima facie, be understood to be an attestation at the time of receipt of these documents.
But only this thing is available with me, and according to this,
Is there no letter? Is there no
nothing-
forwarding letter?
nothing was given.
Then what can be done here?
Nothing was given, but my pension cost was deducted.
Where is that pension cost being deducted?
Page 174.
Where do you say that?
That is 27,552. It was deducted. And it was refunded also. And it was refunded after 13 years when I was paying for pension.
So why was it refunded?
They say they have not received the pension.
Then,
Now they say they have not received the pension.
then
But all these years, my pension my deducted from me.
which year did you submit?
Yes,
Which year did you submit?
2010. 2011 year.
2010.
Yeah.
And when was it refunded?
2023.
So what happened for all these years? What were you doing?
All these years I am serving in bank, and all every month my salary slips bears that I am a pension of me. So I was
Where is your salary slip?
salary slips are there from page 178 to 190.
Where is that indication or endorsement?
PF pension.
Right hand side,
Right hand side.
right from the pen in the below, option is showing as pension.
Then who has drawn up the salary slip? Who has prepared the salary slip?
That is personal department.
Then how can they give an endorsement that it is a pensionable employee unless there are papers?
Your Lordship, there was no paper. But
How can the authority say that it is pension? There are options given: PF, pension, NPS. Why this option was given? Why this option was given by the personal department?
2015, when the system was migrated.
We are asking you something. This is something which is not handwritten.
Yes, it is in computer generated.
Computer
software
generated.
copy.
So computer generated means somebody has given this indication that he is a pensionable employee.
Your Lordship, there was
Either
no
there
deduction
has to
against
be-
the pension.
Huh?
But there was no deduction against the pension. It is only once in the year of 2011, 27,332 was paid to us, along with two other applications.
What is the offer of pension?
Now, for a pension, my lord, was I have to pay one time 2.8 times of my November to 2007 basic pay.
Have you paid that amount?
Yes.
When did you pay that amount?
That
In
is
2010. No.
11.
No.
Then how can
Paid
you
in
pay this
2000,
amount
yes.
if there are no papers? Why will the bank receive his amount without the papers being there?
There may be an occasion that they have deposited the amount, but they have not submitted the application.
No, but what has happened to that amount?
That has been refunded in the year of 2023.
How? How after all these years? Who are the officers responsible here?
It is only the personal department.
Then
And my lord, every month my bank's contribution towards pension was also deducted all these years.
so who personal
Yes.
department
Salary slips
department
too.
from which personal
My lord,
department
salary
is
slips
where is it located? Where is the office of the personal department?
It is head office Calcutta.
Then how can it be done like this?
My lord, similar cases happened in other cases also in other area. In Manipur High Court, similar cases appeared. I have mentioned in my petition also.
Get the order? Is it pending or disposed of?
Disposed of.
You get the order? Let us see.
Right now, order is not with me.
Are you instructed by the personnel department?
Your Lordship, it is General Office, Guwahati. General Office.
You get your instructions from the respondent number 3?
Yes, sir. But there was no direction. I will take the appropriate instruction for that.
You take the instructions, why? Or we'll have to issue directions against the general manager.
I'll do take care.
Heard counsels for the parties. Mr. What is your name?
Manoj Rai.
Mr.
Manoj Rai.
Mr. Manoj Rai, learned counsel, appearing for the petitioner, submits that the claim of the petitioner is grant of pension for the services rendered to the UCO Bank
Yes, sir. Lordship.
after his superannuation. Stop. He had opted for the pension scheme initiated by the bank in the year 2010 and had applied with all necessary documents and made the one-time deposit in the year 2011. Stop. The necessary charges for processing his pension papers were also deducted by the bank. Stop. However, no pension was released to the petitioner after his superannuation. Stop. Subsequently, in which year did you got back your refund?
2023. 2023.
In the year 2023, the amount which was deposited by the petitioner was refunded by the bank. Stop. Where Mr. M. Sharma, learned counsel representing the bank, submits that as in terms of his instructions received, there were no papers received in the personal department of the bank. Stop. Petitioner did not submit the requisite documents, clearly indicating his option for getting the benefit of pension. Stop. According to the instructions received, no papers are available either in the branch or in the zonal office in respect of the writ petition. Stop. Whereas this claim of the respondent is disputed, further disputed by the petitioner on the ground that his salary slip indicated that that his services were pensionable, and that apart, the one-time payment required to be made by the petitioner while opting for the pension scheme was duly made by the petitioner, which, however, was subsequently refunded in the year 2023. Stop. Right, 2022. Stop. Where learned counsel for the petitioner therefore submits that the bank be directed to grant his pensionary benefits in terms of the scheme that he adopted for. Stop. Where Mr. Sharma submits that he is yet to be instructed on the status of any documents being available in the office of the Personal Services Department of the UCO Bank in Calcutta. Stop. He therefore submits that he therefore prays for some time to complete his instructions in respect of the availability of the relevant papers belonging to the petitioner in the office of the respondent number 3. Let the matter be listed again. Accordingly, let the matter be listed again on 4th of April. 4th April. District Court.
When minor punishment imposed, my lord, corporate hearing is not necessary.
Where? From which document? Which order you say so? Which rule?
Yes, my lord, rules, my lord, disciplinary rules also there, my lord.
Let us see.
And I am relying on a case, my lord, Honor Supreme Court. But you kindly see.
Where is the counsel for the petitioner?
Day before yesterday, he told me that his part is completed. Kotaku. This case law is, my lord, ratio recently, my lord, national justice. Personal hearing is not necessary in regard to inflicting minor penalty. So here also, my lord, in this case also, my lord, compliance from the Public Service Commission was taken. And upon having this, my lord, compliance and considered and imposed penalty. Stoppage of implement. This is the case. Same thing.
No, but this does not deal with the Assam Discipline and Appeal rules.
Assam disciplinary rules, lordship kindly see, minor punishment, my lord, rule, lordship kindly see, my lord, 9.
9.
9 minor penalties. Page 275 this book, my lord.
Yes. Clause 11.
Minor penalties. Major penalties, minor penalties 11. If the disciplinary authority, having regard to its findings on the charges, is of the opinion that any of the penalties specified in clause 1 to 3 of the Rule 7 should be imposed, it shall pass appropriate orders, and in every case in which it is necessary to consult the commission, shall do so after consulting the commission. So in this case, they consult with the commission.
But you are supposed to give the
provide the that is, they did not do it. It is not a fatal, I think, in taking decision-making process. Non-punishing.
No. How do you say it is not fatal in the face of the judgments?
Yes, this judgment says, my lord, this judgment also did not provide it. Dr. Policy paragraph 4.
Which judgment?
This judgment I have given you.
No, not this judgment. You see this Narula judgment. Tell us.
Neula, yes.
Tell us.
Neula is in case of major punishment, man. Is a major punishment. I have seen, man. Yes. There, paragraph 2, thereafter the proceedings were sent for opinion of the Union Public Service Commission, and the Union Public Service Commission gave an opinion to the effect that appellant's pension shall be reduced to the minimum and he shall not be granted any gratuity. The disciplinary authority accepted the proposal of the Union Public Service Commission and imposed the state punishment. That is the major punishment. This is the opinion of the Public Service Commission. It is to be noticed that the advisory opinion of the Union Public Service Commission was not communicated to the appellant before he was heard by the disciplinary authority. The same was communicated to the appellant along with the final order in the matter of by disciplinary authority. This is final order because in a major punishment, when there is contemplated to impose major punishment, second show cause is necessary along with the report, and then ballot that is along with the public commission service that was given to him because it is a major punishment. Now, in this case, in a hand ballot, it is a minor punishment. So, in minor punishment, the authority has come to the conclusion that this is in this after the inquiry and impose minor penalty. It is a never case. This and this case, my lord, what my case is, my lord, also penalty. Justice Tamam. State of Punjab versus Nirmal Singh. This case, my lord, paragraph 4. May I read in, my lord? The competent authority appointed S.D. Gupta, Region Superintendent Engineer, as the inquiry officer. The inquiry officer submitted a report exonerating the respondent of the charges leveled against him. The competent authority disagreed with the findings of the inquiry officer, and notice was issued to the respondent along with a copy of the inquiry report and dissenting note. The respondent filed a reply to the so-called notice letter dated 21 January 2000. The reply was rejected by the affording the respondent an opportunity of personal hearing. Thereafter, the disciplinary authority, with the concurrence of the Punjab Public Service Commission awarded punishment stoppage of 2 annual increments with cumulative effect by an order dated 20th October 2023. Aggrieved thereby, the respondent filed a review appeal before this authority on demand. The said review appeal also rejected and hence the writ petition in the High Court. The only ground on which the High Court has set aside the order of punishment dated 20th October 2003 and the order passed by the Complaint Authority in review dated 24/6/2004 rejecting the review appeal was that there was violation of the principle of natural justice inasmuch as the opportunity of personal hearing was not afforded to the respondent while dismissing the review appeal by the order dated 24th June 2004. Paragraph 6. Rule 21 of the Punjab Civil Service Punishment and Appeal Rule 1970 deals with the review. A perusal of the aforesaid rule shows that there is no provision of personal hearing in regard to inflicting minor penalties, like this our Disciplinary Rule 1964. The rule contemplates a personal hearing only when the disciplinary authority proposes to impose any major penalties specified in clause 2 and so of the rule, and to enhance the penalty imposed by the other sought to be reviewed to any penalties specified by those clauses. Admittedly, by an order dated 20th October 2003, the respondent was inflicted punishment of stoppage of 2 increments with cumulative effect, which is a minor punishment. The High Court, in our view, was clearly in error in setting aside the order dated 24 June 2004 passed by the competent authority on the ground of violation of petitioner justice. The High Court was also with the view that the order passed by the competent authority dated so and so is not a sitting order. The finding of the High Court was not based on material on a record.
What is the punishment imposed here?
Here only 1 increment stopped. And during that period, he was not given punishment, promotion. That is the issue. So by this case, my lord, by the Supreme Court, and also, my lord, ECL case also, my lordship. ECL case, my lord, I have the 11th portion. I am reading it, my lord. 1993 4 my lord.
No, see, I don't know why the councils are not developing this practice. Whatever judgments you have, you give a list so that these judgments are ready before us.
Paucity of time, I'll provide you.
What paucity of time? If you want us to go through the judgment, we should have these books ready with us.
Actually,
or you don't want us to go through?
No. No, I'm giving a lot to my lord.
No, you don't have to give us. You give us a list of the books. What you want to propose to rely on and share it with the council for the other side.
This
is a practice to be maintained by both sides.
Rightly.
Somewhere it got lost.
Only 3 lines I will read from this judgment. Non-punishing of the report. After the Ramzan Khan Malad, Mohammad Ramzan case Malad, the ECL case they have said Malad in the paragraph 30. Thus I am reading Malad. The next question to be answered is what is the effect on the order of punishment for a report of inquiry officer is not punished to the employee, and what relief should be granted to him in such cases. The answer to this question has to be relative to the punishment awarded. It is related to punishment, what punishment awarded, nature of punishment. When the employee is dismissed or removed from the service and the inquiry is set aside because of report is not punished to him, in some cases, the non-punishing of report may have prejudiced him gravely, while in other cases it may have made no difference to the ultimate punishment awarded to him. So, non-punishing of the report also it is not a fatal. And what is the prejudice that is not mentioned in the petition? I have nowhere found this word. He has not mentioned the non-punishing of the opinion of the Assam Public Service Commission. There is a prejudice. So
he doesn't know because you did not give him a copy. How will he know?
No, Mara,
what the APSC said, he did not know. How will he know that?
APSC only agreed with the proposal of the competent authority, disciplinary authority. That's why, my lord, they have imposed the penalty. So, non-punishing of the report is not a fatal and what prejudice had it been given, my lord, how it would be, my lord, they develop his case. That is the why, my lord, this case is, my lord, in minor punishment, my lord, there is no provision also personal hearing, and also providing the copy, it is not an inquiry copy, only opinion of the APSC. And Assam service disciplinary appeal 64 also, there is no provision for participating on the minor party.
How do you say that?
And he admitted it.
No, how do you say that in the rules there is no provision? Your procedure is very clear, Rule 9.
Rule 9.
Rule 9 is a very clear procedure.
Without prejudice to the provisions of the public servant execution, no order imposing on government servant any of the penalties specified in Rule 735 except after an inquiry held as far as may be and manner hereafter provided. The one of the so-called notice was given to him. He replied also. He admitted his fact. The disciplinary authority shall frame definite charges on the basis of allegation on which the inquiry is proposed to be held. Such charges, together with a statement of allegations on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified by the disciplinary authority a written statement of defense, and also state whether he desires to heard in person. That is the ballot. That has formality has been observed in this case. He was given a so-called notice. He replied. He admitted that he done the wrong. In affidavit, in our affidavit, my lord, page with yes, our affidavit also kindly affidavit filed by response 2, 3, and 4. It is the page 20 in excess 6. Submission to reply to so called. He admitted, my lord. Last portion.
Page number?
Page number, my lord, our affidavit, my lord, I think internal 21. Last step from 20. He replied to so called. Affidavit filed by response 2, 3, and 4. Secretary, Joint Secretary of Government of Assam, Person 8.
Ikramul Hussain.
Yes, my lord. Lordship, Kalisi, page 21. 8, column 8. His reply, my lord. That, sir, it was not my intention to commit any act of indiscipline and mislead any higher authority. It happened inadvertently because of my high confidence level on the subordinate officers and staff of SSA Corpeta. Therefore, I request you to kindly consider my above submission favorably, and the charge which I hereby admit humbly may kindly be dropped in view of my superannuation in the month of May next year, and allow me to discharge my duty for the remaining days. This is what he admitted to. So the minor penalty only imposing a one increment minor. And he had not mentioned any whisper about the prejudice of this non-punishing of the opinion of the. That is the. So when he admits penalty, he gives also only instead of doing any further penalty, only impose on one increment, proposal of one. The first so-called notice was issued in the 39. Issued on 20th January 2015, and he replied also to submit my law. State of allegation is there, but there is no any procedure left in the department.
Yes, anything? But
already whatever regarding the judgment which my learned senior officer has given today, my lord. If my lord permit for Monday, my lord, my senior will
27 March for orders. If you want to submit anything, submit.
Yes,
or we pass orders on 27 March.
Yes, 5 or 10 minutes.
My custody kept on report.
Yes, we have kept it. You give a list, both of you. Heard counsels for the parties. The for further hearing on 27th of March. Stop. Attempt will be made to dispose of the writ petition on the same day. List accordingly.
May I please your lordship? Lordship, matter relates to resignation of the petitioner under duress and coercion, lordship. Lordship, he was appointed as a rifleman in the Assam Rifles on 15/5/2009. On Lordship, fateful day of 3/4/2013, while he was performing night duty, Lordship, he went to his quarter, and by mistake he knocked on the door of some other quarter, wherein Lordship, one lady, allegedly wife of SC Das, she came out of her quarter and started shouting and abusing me. Then Lordship, in the next day, Lordship, the respondent number 5, I have made him a private respondent, the commandant. He called me to his chamber and started abusing me and also beat me, Lordship. And he was also accompanied by other superior officers. I have named everybody in the writ petition at page 3, Lordship. I have named them. And due to such beating, Lordship, I was admitted in the Assam Rifles Hospital for a period of 12 days. Lordship will kindly have a look at the discharge certificate of the hospital, which is at page discharge certificate at page 27, running page 27, enclosed with their affidavit in opposition. I was not given all those documents also. I got it as an annexure to their affidavit in opposition. On 5/4/2013, I was admitted. Date of admission 5/4/2013, page 27. Page 27. Then date of discharge is 16/4/13. For a period of 12 days, I was in the hospital and diagnosis over generalized body ache.
Where do you stay? Where is your quarter?
I stay, my place of posting, Lordship.
Where?
Mantri Pukhuri.
What is the distance between your quarter and the quarter that you, according to you, mistakenly knocked on?
Lordship, it was...
is there any finding?
No finding regarding to that, Lordship. I'm just placing the facts, Lordship. The matter traveled much thereafter, Lordship. Lordship will have a look at page 27, Lordship. Discharge certificate from the hospital. Diagnosis, generalized body ache. Generalized body ache. For that, Lordship, I was admitted on 5/4/13 and discharged on 16/4/13. Then, Lordship, in the hospital, I have made all these statements. I will come to the records, Lordship. First, these are statements, Lordship, my averments. While in the hospital, Lordship, these superior officers, some of them, they came to me and they have collected signatures on blank papers and also some certain forms. My signatures were taken. Thereafter, Lordship, my wife was pregnant, and after being released from the hospital, discharged from the hospital, I was on leave. And after returning from the my leave, I was shocked to receive the discharge certificate, which is Annexure 1 of the petition, writ petition, Annexure 1. Discharge from the service. Their Lordship, at page 12, they mention discharge from service at his own request. Page 12, they mention discharge from service at his own request. Then, Lordship, I inquired in the office. I came to realize that the pages on which they have obtained my signature, those documents they have used for preparing my resignation letter and also an undertaking. Now, Lordship, after receipt of this discharge certificate at page 11, I submitted an appeal at page 15. Appeal at page 15. Therein, I have mentioned, not much annexures are there, Lordship. Annexure 2. I, so-and-so rifleman, have the honor to inform you that I was enrolled in an Assam Rifles on 15 May 2009. After completion of successful basic training, I have been posted at 30 Battalion Assam Rifles during my service period. I always served my duty faithfully. That, sir, I came on leave during September-October 2012 in the prevailing situation Garo Hills at present. I was compelled to bring my family to my unit without prior permission of higher authority. That, sir, this is a blunder mistake as a young soldier.
That application stated to have been submitted?
That document was not with me. This court directed the respondents to produce records, and they have produced it along with their additional affidavit, which is at page 44. Now, they have enclosed two documents. Now, my appeal was rejected at page 16. And now, Lordship, I am coming to their document, directly to the additional affidavit. they have enclosed two documents. First, Lordship resignation letter, page 47. Page 47.
Yes.
Then Lordship an undertaking, page 49. That undertaking, page 49 is the undertaking. This is a typed page. And this undertaking has also been obtained on the same date. Date is same, Lordship will see, 16/5/2013. 16/5/2013. Resignation letter is also dated 16/5/2013. Now, Lordship, coming back to my case, I will come to this undertaking letter also. There is a procedure, Lordship, how after a person submits resignation letter, if at all he submits, then what procedure respondents should adopt. They should explain him that these are the consequences.
Right.
I have a copy of the Act, Lordship. Here, Lordship will have a look at section 8. Section 8. If your Lordship will have a look at my resignation letter, I have not mentioned. If your Lordship will have a look at my resignation letter, I have not used the word resignation. Although my allegation is that they have prepared it, the word used is voluntary retirement. However, there is no provision of voluntary retirement under the Act. Under the Act, so Lordship, they have relied on section 8. Lordship will have a look at section 8. They have considered it to be resignation. Resignation and withdrawal from post. No member of the force shall be at liberty to resign his appointment during the term of his engagement, or to withdraw himself from all or any of the duties of the appointment, except with the previous permission in writing of the prescribed authority. This is not there in my case. There is no previous permission in writing from the prescribed authority to submit my resignation. There is no previous permission. Then Lordship will have a look at section 15. 1.5. 1.5. Remedy of aggrieved person other than officers. Number 2 is relevant, subpara 2. When the officer complained against is the officer to whom any complaint should under subsection 1 be preferred, the aggrieved person may complain to such officer's next superior officer. Now my appeal is my complaint. Then Lordship, what they should do, subclause 3, every officer receiving any such complaint shall make as complete an investigation into it as may be possible for giving full redress to the complainant, or when necessary refer the complaint to superior authority. So there is no investigation also in my case. They have not done any investigation subsequent to.
There is an order passed earlier by coordinate bench. Similar.
Yes, I have got that judgment, Lordship.
Have it?
This is regarding undertaking. How undertaking is to be dealt with. How an undertaking is to be dealt with. 2019 2 GLT 386. 2019 2 GLT 386. 2019 2 GLT 386. Here, Lordship, kindly have a look at para 12. Here, a circular has been relied upon wherein it speaks about the manner in which the undertaking is to be should be dealt with. In this regard, learned counsel for the petitioner, I am reading para 12, Lordship. Petitioner has drawn attention of this court to a circular issued by DG of CRPF dated 17/5/19, which called upon all the authorities to ensure that any application for discharge or voluntary retirement are submitted for genuine reasons and voluntarily. It has been further provided in the circular that to ensure that such applications for discharge or voluntary retirement are genuine and for compelling reasons, the authorities concerned should obtain an undertaking from the individual to that effect, and that he has been explained in detail about the likely hardship which he may face in this uncertain and difficult economic age of his discharge on voluntarily, and such undertaking should be kept on record. Then the circular has been quoted. Para 2 I am reading, Lordship, below circular. In this context, the instruction regarding the procedure to be followed in accepting resignation and withdrawal of resignation as contained in so and so OM dated 10/12/88 should be clearly understood and explained to the men. It is imperative that the authority competent to accept the resignation should therefore personally explain the growing unemployment problems and consequences of discharge to the persons seeking discharge from service. While it is not in the interest of government to retain an unwilling government servant in service, a care has to be taken that no one is allowed to proceed on discharge voluntary retirement without any compelling reasons. As a model employer, the administration must conduct itself with high probity and candor with its employees and should always be careful enough to listen to their problems. The authority competent to accept the resignation should therefore ensure personally that the person seeking discharge voluntary retirement has genuine and compelling reasons. To ensure it, the authority concerned should obtain an undertaking from the individuals to the effect that he has been explained in detail about the likely hardship which he may face in the uncertain and difficult economic age after his discharge, voluntary retirement. Such an undertaking should be kept on record. Then, Lordship will have a look at para 23. Para 23. Perusal of the undertaking certificate would indicate that the undertaking was only to the effect that the petitioner understands that in the event of his discharge at his own request on extreme compassionate ground be sanctioned, he would not be entitled to any pensionary benefits for the service rendered. This undertaking does not at all deal with the issue as to whether he had given the discharge application voluntarily or not, and whether the authorities explain to him the implications of such discharge applications in terms of his income, etc. The said undertaking merely refers to the fact that in the event his application is accepted, he will not be entitled to any pensionary benefit. Then para 24, normally the authorities cannot be faulted with for acting promptly and expeditiously in any administrative matter. But the issue which arises for consideration before this court is whether the manner in which the authorities proceeded in post haste under the circumstances could be considered to be proper or not. Then, in this regard, a reference has been made by learned counsel for the petitioner to a circular, which I already read. Then 26. Then Lordship will have a look at para 28. Para 28. A perusal of the record, said records do not indicate that the petitioner was personally examined by any of the members of the standing committee to ensure that he had given his discharge application voluntarily, and that the committee had given the findings that no undue pressure by any authority has been exercised over the individual who had applied for discharge from service, and that he had done on his own wisdom after examining the relevant and concerned persons, including the applicant. In absence of any materials or documents on record as to how the committee has come to such a conclusion, this court is not able to accept such a conclusion by the committee that petitioner had voluntarily applied for discharge. There is nothing on record to indicate, as mentioned above, that the members of the committee had interacted with the individual concerned or any other members of the unit. Therefore, if such finding has been arrived merely on the basis of examination of the application, which seems to have been done in absence of any other materials in this regard, this court would hold that the findings given by standing committee cannot be said to be proper. Non-application of mind by the standing committee on the particular issue of voluntariness of the petitioner is quite apparent on the face of the record. The undertaking given by the petitioner also has nothing to do with the issue as to whether he had given the application voluntarily, as the said undertaking was given only as regards his entitlement of his pensionary benefit. Therefore, this court is satisfied that there was no attempt by the authorities concerned to examine properly as to whether the application for discharge from service had been voluntarily given by the petitioner or not. In that view of the matter, this court is of the opinion that all the subsequent actions taken by the authorities would be vitiated for the reason that the initial decision to accept discharge application for the petitioner itself stands vitiated. Then para 30, in the result, the reasons discussed above, present petition is allowed, the impugn order dated 5/11 is set aside, and the petitioner will be liable to be reinstated in service, however, without any benefit of back wages. Petitioner, however, will be deemed to be continued in service for the period of purpose of other service benefits and retired benefits. And Lordship will have a look at the resignation letter, Lordship. Undertaking, page 49. It is already a letter prepared by them, and it only says that it only says that once my discharge order issued, I shall not change my mind to seek cancellation of my discharge from service at my own request. But Lordship, and it will, Lordship will kindly appreciate that it was prepared on the same day, Lordship, same day of the alleged so-called resignation letter, 16/5/2013. And there is in the so-called undertaking, Lordship, there is no mention about that I submitted it voluntarily or what would be my future prospect, whether I'll get anything, whether anything has been explained to me, was there any counseling, nothing. So,
No, but where is it to be recorded?
there was
Whether a counseling is to be given, not given, it was given, whether it was meant to be understood or not. Where is it to be recorded?
it is in the selection in the committee minutes. It should be recorded.
Which committee minutes?
Lordship, in the judgment also it has been mentioned that a committee should examine him. I have already read, Lordship.
Committee is in respect of what?
After he submits the
No,
application.
is it in terms of the act or the rules?
Rules, Lordship, Act do not provide any such examination by the committee.
No, must have particularly some circular perhaps. How will the court come to a finding that it is on the standing committee?
Yes.
It was examined by some standing committee.
Yes.
In your case, what is the, who examined it?
No, Lordship, in my case, they have not placed on record the standing committee minutes. I was never given hearing.
Therefore, I am asking you, under what provision these standing committee minutes are to be made available, or whether there is a standing committee which is to accept the resignation. Rule 8 does not talk about that.
Act do not provide so, but
there must be circulars. Must be.
There must be circulars, but
otherwise, from where will the coordinate bench get this finding that the standing committee was convened? Maybe it was reflected in the order itself. You read para 4.
The said application was submitted on 12/8/11, and on the same day it was recommended by the commandant for acceptance, and on the same day a standing committee was convened to examine and to rule out the possibility that no undue pressure in the unit was exercised over the individual to put up the application for discharge from service, and the standing committee recommended acceptance of application of discharge.
So where is that procedure prescribed? Mr. Sharma?
My lord, in the last occasion, Lordship was pleased to call for record, my lord. Yeah, I have the record, my lord. Here, all the things are here, my lord. Here, board was constituted to find out his own or not, my lord. Then after three members, and thereafter it was recommended. Thereafter, Lordship, here is the counseling also. He was given the counseling, my lord, for his my lord. What I but he is in, my lord. He is reluctant to submit resignation back after the counseling also, my lord. It is very clear, my lord.
You go through this.
Yes, my lord.
Allow him to go through it.
My lord. Another submission is that, my lord, whatever story he has submitted, my lord, that he went to the house of the another person in the after duty, my lord. This taken in their repetition, my lord. They taken the state in the
right, that is a matter of fact. It is asking.
My lord. Thereafter in appeal they have filed taken understandment. Before Lordship may kindly produce the My lord,
Where is the appellate? Where is the appeal?
my lord, appeal is my lord, annexure 2, my lord, of their requisition, my lord. Page 15, my lord. Page 15, my lord.
Yes.
Married, my lord.
Yes.
Number so and so, I was enrolled as so and so, I was served my duties faithfully. That's sir. I came on leave during September so and so in the prevailing situations of Garo Hills at present. I was compelled to bring my family to my unit without prior permission of higher authority. That's sir, this is blunder mistake as a young soldier. Major SM Bhutian so and so gave me heavy punishment in which I had to admitted into Assam Rifles. Here's another story, my lord.
Heavy
How
punish-
you will believe, my lord? that
Lordship,
is
heavy
statement?
punishment herein means, Lordship, heavy beating, Lordship.
Let me complete. My lord, here in appeal, my lord, and appeal also filed, my lord. He was discharged from service, my lord, on 1/10/2013, my lord, and his appeal was filed on 18/11, my lord, 2013.
Here the story
My
which
lord.
you stated in the petition is not there.
My lord.
Here, Lordship, he says that those two persons gave me heavy punishment in which I was admitted into Assam
No, no, no.
Model
Prior
Hospital.
to that is a consequence.
My lord.
That is a concept.
Why the punishment was given?
My lord.
According to you, you mistakenly knocked on somebody's door.
My lord.
Somebody's wife came out and
Yeah.
in 2 in the morning, etc.
Yeah.
Here the ground is
Appeal,
different.
my lord.
Here the punishment was imposed because you brought your family with you without permission of the higher authority.
But Lordship, beating is not disputed. Beating, Lordship, here it is common.
Beating you, go and file an FIR or
My lord,
lodge
my
a
lord.
complaint before
Not
the
filing
authorities.
FIR or complaint, my lord.
Did you lodge any complaint
Lordship
before
will
the
kindly
authorities?
appreciate, Lordship. He is a lower rank employee and these are defense forces, Lordship. They themselves behave like, Lordship, they are
No.
commandant people. Lordship.
We are not here to tell how the forces are to be handled or disciplined. It's not our job. But yes, if there is any prejudice faced, we'd like to go through it. So you go through these documents which are there.
My lord.
There is your statement that it was accepted and there was no counseling, etc. doesn't
Right.
appear to be correct on the basis of this record. So therefore, if you want, you can go through it.
I will
We'll take
go
up the
through,
matter again at 2 p.m.
Lordship, then some other day I will go through, Lord.
Small, my lord, 4 pages.
Just 2-3 pages.
My lord.
You go through and tell us if you want. Or you want some other day.
Some other day, Lordship, I will go through this.
All right. Some other day.
Right.
Heard learned counsel for the party. During the course of the hearing, certain documents, the records pertaining to the consideration of the petitioner's application for voluntary retirement, is it? Was considered by the what committee?
My lord, board, my lord.
Board.
It
Is available.
my lord.
Counsel for the respondent at the court has permitted the counsel for the petitioner to go to
My lord. Record, my lord.
these
Original
documents, subject to there being no objection from the counsel from
Right.
the respondent. Stop these documents must be perused in the presence of the counsel for the respondent in court.
My lord.
Stop. Counsel for the petitioner therefore submits that matter be deferred to be taken up after 1 week. List this matter again after 1 week.
Right.
Can it be on 25, Lordship?
It will come after 1 week.
My lord.
1 week. Obliged.
Obliged.
No. My lord, item number 9, my lord, kindly accommodate me. I have missed the brief, my lord, today.
2014.
I can understand, my lord.
We will give you enough time.
My lord, I prepared the case, my lord. But by mistake, my lord, brief, I could not have been brought, my lord.
No worries. What is the matter about?
Matter, my lord, simple matter. Anganwadi worker, my lord,
Hmm.
and she was, my lord, ultimately dismissed from service without holding any department proceeding. And law is laid down by this court that disciplinary rule is applicable. And there is a stay order.
How can there be there is a stay order on discharge?
Yes, my lord. And actually, I prepared the case, my lord. I've brought some decision. Unfortunately, my lord, different brief has come. Any date, my lord, on Tuesday, my lord.
All right, Thursday.
Sorry, my lord.
Next Thursday.
Obliged. And
And the
interim order,
request of counsel for the petitioner that he by oversight, he did not carry the brief of the matter to court. He prays for a day's accommodation. Let the matter be listed on 2020.
My lord.
Yes. This is item 9, huh? Yes. Yes.
Please, Your Honor. This writ petition was disposed of in 2023, in the month of June 2023. Thereafter, Your Lordship, we had preferred a writ appeal. This is the order of the writ appeal, Your Lordship.
Here. Rate appeal 369.
Yes.
36923.
Where
Yes.
this matter, Your Lordship, was remanded back. Before Your Lordship, today the matter has been listed. What had happened was, when the writ petition was initially disposed of, a parity was drawn with one certain other colleague of the petitioner. That was directed to be brought on record by this honorable court, which had been done, and pursuant thereto, Your Lordship, it also filed an affidavit in opposition. On May 2024.
Then you have filed.
Yes, we have filed our reply also, additional affidavit in opposition to the affidavit which has been filed by my learned friend appearing for the
No,
petition.
you were supposed to file an additional affidavit to bring on those grounds.
No, they were.
They were supposed to file.
Yeah,
Okay.
they have done
You
that.
filed it.
We have done that one.
Then?
Then, pursuant to that, Your Lordship, we filed our rejoinder on May 2024.
2024.
It is, we have termed it as
25.
an additional affidavit in opposition. Pleadings are completed in the matter. My friend had stopped time yesterday on account of some difficulty of the PDF.
Yes. Where is your senior?
It's out of station is for some personal work, my lord. Next week, my lord, last task may be given, my lord. Next week, my lord. I'll say better.
Next week.
Next week,
20.
23, my lord.
All right. Heard Mr. A. Bhattacharya, learned counsel for the petitioner, and Mr. M. Sharma appearing for the respondents. It is submitted at the bar that this petition was earlier disposed of, and against which an appeal was filed by the respondents. Stopped before the appellate court. It was submitted that the writ petition was earlier allowed on the grounds of parity, but these were not urged in the proceedings, writ proceedings by the writ petitioner, and consequently there was no opportunity. There was no occasion for the respondents to rebut the same, and they were denied of the said opportunity. So, on such submissions made before the appellate court, the order of the coordinate bench was set aside and the matter was remanded back. Stop. The order of the appellate court was issued in writ appeal number
369
369.
of 2023.
369/2023. An order dated 3/10/2023. Pursuant thereto, the petitioners have filed an additional affidavit containing additional grounds, and to which the respondents have also filed their reply. Stop. Both the counsel submit that since the matter is ready for disposal, ready for hearing, the matter be taken up for hearing on in the next week. Stop. In the next week, as the arguing counsels of both the parties are not available in court. Stop. Accordingly, as agreed to by the counsel for the parties, matter is directed to be listed on 20 March for hearing.
As I already made a prayer for
Yes.
any other day, Lordship will kindly be.
Why? What is the difficulty today?
Lordship, being very honest, the matter was handed over very recently, and once I've gone through, it's very complicated for me to understand at the very first instance.
We'll help you to understand. What is the issue, madam?
Your Lordship, there are some consequences, and there are some consequences in this matter. And as I am new to this matter as well, my senior counsel is out of station.
Who is your senior counsel?
Your senior counsel, Hospital Course, sir.
Huh?
BD course.
BD Course, sir. Any next earliest will be
Basically, the petitioners joined as an assistant company secretary, and she has reached the highest level of post in her career, and she's claiming for creation of the post and upgradation to next higher pay scale, which is pay scale of the general manager of AIT slot. And that post happens to be a post created by Public Enterprise Selection Board. It's not in the career of the company secretary. That is the controversy.
Petitioner is still working.
Yes, Lord.
As company secretary.
As a company secretary. She has 3 years of service left as on date.
What is the age for superannuation?
That will be 60.
Are you sure?
That's why I cannot issue, but that
You don't even have that instruction. What is the age for superannuation?
still under limited instruction.
If you are unable, then you must make attempts to find out. Mere appearance in court is not helpful.
An humble apology, Your Lordship.
Counsel submit that the matter be taken up for hearing on some other date. As the counsel for the petitioner submits, the lead arguing counsel is out of station. And counsel for the respondent, Mr. D. Dekka, submits he's been recently engaged in the matter. His instructions are not complete. Mr. N. Golita appears for respondents 2 and 4. List again after 1 week.
Good.
Mr. T.C. Sutia appears for respondent number 1.
Highly applied.
Yes.
May I have your lordship? Some other day, maybe kindly, lordship. I have to control the entire matter, lordship. I am newly engaged.
How can anybody be newly engaged in a 2015 matter? Tell me.
Lordship, earlier, lordship, my lord Nayar sir was engaged. My lord Justice Nayar was engaged on it, and thereafter, lordship, it was at least 2 weeks, lordship, I'll my part.
Yes. Mr. A.M.S. Mazumdar, learned counsel for the petitioner, submits that. When were you engaged? When were you engaged?
Lordship, last month, lordship.
Last month. Have you filed your power?
Lordship, I have filed.
Where? We don't find it here.
My name is also reflected in
Your
the
name may be reflected, but you have to file the power. You're not a senior counsel.
I have filed.
Where is it?
There was a lordship, the name is reflected.
Photo there. Mr. A.M.S. Mazumdar submits that he has been recently engaged in the matter. And he is yet to complete his instructions. He submits the matter be listed after 3 weeks. M.S. Ebora appears for the respondents list after 3 weeks.
This matter also I thought for some time because some instructions are thought for. Here in Lordship, it relates to basically stagnation in service, Lordship. Stagnation, Lordship. Lordship, what had happened, they were promoted in 2014, Lordship, and subsequently they were not promoted. And I have been told, Lordship, that juniors were promoted subsequently, Lordship, but those juniors' names, Lordship, had not been given to me, Lordship, and they are posted out of Assam, Lordship. So, Lordship, sometime is being sought for.
At the request made by the counsel to the petitioner, matter stands deferred to be listed after 3 weeks. M.S. So-and-so appears for
M. Burman on behalf of Mrs. A. Gahan.
M. Borman on behalf of
Mrs. A. Gahan.
Mrs. A. Gahan. For CGC. After 3 weeks.
Right. In item 14, an affidavit has been filed, and therein they say that, Lordship, I am continuing in that post of artist. Actually, case relates to my ouster from that post of artist, which I was holding. And Annexure 1, page 11, is the order, Lordship, whereby I was ousted from this post, and I was required to serve in as office assistant. The third paragraph, Lordship, page 11, as your Lordship got it. The I was required to serve as office assistant in the Department of Pulmonary Medicine, Guwahati Medical College, Lordship. Whereas I was appointed as an artist in the Department of Pathology, Lordship. Now,
appointed as a?
As an artist in the Department of Pathology.
Then?
This Lordship, this order was, in the affidavit, they have stated that this order was in order to meet the exigency that arise during the time of COVID, Lordship. But this state, and subsequently, when I raised objections and said that I do not have expertise to hold that post. What they did is, Lordship, they ousted me from Guwahati Medical College itself, Lordship. That is at page 16 now. I was released from that post from Guwahati Medical College itself and placed under the disposal of the Director of Medical Education. I approached this court.
Come to the who's filed the additional affidavit by the health department.
Yes, Lordship.
You have got a copy of that.
Yes, Lordship, I got it.
Please read the para 2.2 Roman 2, page
Yes,
number
Lordship.
39.
Yes, Lordship. It is being stated that the post of artist he has been holding is not lying vacant. He is still holding the said post of artist without break since his appointment. It may be mentioned here that the post of artist has not been converted into office assistant as mentioned in the Honorable High Court's order dated 21/11/2024. Due to shortage of official manpower as well as shortage of junior assistant and senior assistant, he was engaged as office assistant in the Department of Pulmonary Medicine, GMC and H. Guwahati. Lordship, that was at that point of time, but Lordship, no subsequent order has been passed.
Where is the order of discharge?
Destroying the salary of artists.
Where is the order of discharge
Lordship,
or termination?
Annexure 5, page 16 now. This was my release order, Lordship, and I approached this honorable court at that point of time itself, and this court protected me by the order dated 8/21. So, by dint of this,
Where is your appointment order? Original?
My appointment order probably not here. Okay. Not been annexed, but I have it here. So, this is the appointment order as well as the joining report I have annexed.
So you are appointed as an artist.
Yes, sir.
But in this order at annexure 11, you are directed to continue your duty as an office assistant.
Yes, sir.
So now you are subsequently released. What is your difficulty? Why do you say that you have been terminated?
No, release means I am kept hanging, Lordship.
How can it be kept pending? This release order itself says that you are placed at the disposal of the principal, where is that?
Director of Medical Education.
Director of Medical.
Lordship, my prayer is that since at that point of time there was exigency, Lordship, with regard to shortage of manpower, Lordship. Now I can be taken back to that post, Lordship.
Which post?
That post of artist, Lordship. Because I do not have the expertise to hold that post, Lordship.
I don't understand. You don't have expertise to hold which post?
Office assistant, Lordship.
Office assistant.
Yes.
So you have already been placed.
I am placed, but I am Lordship. I
And
am required to serve
the
as-
affidavit of the.
I know, Lordship. They say that I am still holding that post, Lordship. But in factual aspect, Lordship, I am
Your
required to
nature
discharge
of
my duties as an
where are
officer.
the nature of duties reflected under what rules? What is an artist supposed to do? What is a junior assistant supposed to do?
The posts are different, Lordship, and the nature of duties, Lordship, the artist is required to make diagrams, Lordship, and the department is also different.
Now, if it is found that your services are not there, required elsewhere, they're utilizing your service, you are getting your salary.
I'm getting it, Lordship,
Then
but it is
what
Lordship,
difference does it make?
difficulty I have expressed before the authorities, but they did not consider it.
Which authorities? Where?
Uh, giving it,
All right, we'll come back at 2.
Lordship. Lordship will kindly note the sequence of events which have taken place in this case, Lordship. Lordship, on 16 September.
No, your appointment was as an artist.
Lordship.
Now, is there any difference in the salary part? You are getting your pay as an artist.
Yes.
You are doing your job as a
Office assistant.
Office assistant.
Yes, Lordship.
Then
Page 13, Lordship, may kindly see once, Lord.
page
13.
13.
Lord. This is the joining report, Lordship.
Hmm.
I was released on 18th, Lordship, from the post of artist. On 16th, the transfer order came, Lordship. And on 21st of September, I joined that department as office assistant, Lordship. Lordship, the second paragraph, Lordship, I'll read it. I do hereby express my desire to learn the work attached to the post of office assistant, including computer-related work. Accordingly, I request your honor to arrange for providing
What is the job profile of an artist? That's what I'm asking you under the rule.
Lordship, to make drawing on.
Where have you stated that? We know what an artist means.
Yes, Lordship.
What is the profile? Under what provision of the rules?
Lordship, there was an advertisement issued recently,
Yeah.
Lordship, and therein the qualification is prescribed.
Not recently, at the time when you had joined. What
Lordship,
was
was the qualification at that point of time also, Lordship.
Hardly anybody can see it.
Yes, the second point, Lordship.
So I can't see this, sorry.
This is very small, but that was 2 posts were advertised, Lordship, and the qualification was HSLC
Even
pass.
with this apparatus, it is not helping me.
I'm reading it out, Lordship. HSLC passed with degree diploma in fine arts from recognized institute, Lordship. That was the qualification required, Lordship.
Quite right. I'm asking you that as an artist, under the rules or under some circular, this is your job profile and this is what you're supposed to do. Or the rules say that anything beyond what you do, there are certain additional charges, emoluments, or some benefit to be given to you. Or the pay of an artist is a higher, office assistant is lower.
Office assistant is higher, in fact, Lordship. They say it, Lordship. But then
You're not praying for higher remuneration.
No, Lordship. But what I am submitting now is, Lordship, since an advertisement is being issued, Lordship, there is requirement of artist, Lordship, it seems from this advertisement apparently. Now, there is no difficulty on their part, Lordship, if they would revert me back to that post of artist, Lordship.
Yes, why are you making an artist do office assistant work?
Due to shortage of manpower, Lordship.
You fill up.
And I think it is
No,
still
Lordship.
there. So,
But he was appointed when?
I was appointed in 1996 initially.
96.
Yes, sir.
And you are attached when?
In
2020.
2020, yes, sir.
So 5 years shortage of manpower. Why?
then I think Lordship may direct the authority, concerned authority.
I paid, Lordship, page 14, paragraph 5, but that was not considered, Lordship.
You show us from some authority, some route that you have a right which requires the department to ensure that.
Lordship, based on my qualification only, I was appointed against that
I
post.
know. But for what is the job
But
profile?
since I expressed, Lordship, my desire to learn the necessary particulars against the post of office assistant, they denied, Lordship. Did not provide me any opportunity to learn those.
But you are still working as an office assistant.
Yes, Lordship. I was compelled to, Lordship. And that's why this court protected me, Lord.
On what basis? I don't find any merit here.
Lordship, Lordship will kindly also see the release order at page 16, Lordship. I was transferred to other medical college, Lordship. In terms of the interim order only, I was kept here, Lordship. Otherwise, I would have been in other medical college, not here.
No, regarding your claim for being working there, you show us that you are required to work.
Against the post of artist. Lordship, there is shortage of staff. That was what I was submitting, Lordship.
Shortage of staff in the office assistant, not in artist.
No, as artist, Lordship.
Where?
That advertisement, there is no advertisement against the post of office assistant, Lordship. Only against the post of artist, there were 2 vacancies that were.
How many vacancies?
2 vacancies. That was in November 23, 2024, Lordship.
The affidavit says otherwise.
And that was at that point of time, Lordship, when COVID outbreak was there. Lordship will see the language.
We can at best direct you to file a representation. Beyond that,
Lordship, it's already there. Lordship will kindly see once.
yes.
Page 14, paragraph 5, Lordship. That's sir.
This has not been disposed of.
No.
Not disposed of.
No, Lordship.
Right? We directly
That's why I
dispose of.
approached this
That's all.
court, Lordship.
Hmm?
That's why I approached this court, Lordship.
Then why are you sitting with an interim order for all these years?
Because I was transferred to other medical college, sir, and placed under the disposal of the director.
Heard. Learned counsel for the party.
At least that order must go, Lordship.
Petitioner was appointed as an artist by order date number so and so, page number 14. Dated 2/1/1996. So he joined in the Department of Pathology under the Guwahati Medical College Hospital on 2/1/1996. So since his date of appointment, petitioner was working as an artist in the Department of Pathology, Guwahati Medical College. So subsequently, petitioner came to be transferred to the post of office assistant in the Department of Pulmonary Medicine, Guwahati Medical College and Hospital by order number so and so, dated 16/9/2020. This order came to be issued at the time when the country was plagued by COVID-19 pandemic. So the petitioner continued to render his service as an office assistant in the Department of Pulmonary Medicine, Guwahati Medical College Hospital. Although his appointment into the service was that as an artist in the Guwahati Medical College Department of Pathology. So, it is the case of the petitioner that the office assistant bears a lesser pay than that of an artist, and that the duties and functions of the office assistant are different than that of an artist. So the requisite educational qualification for both the posts are also different. So, it is further submitted that there are 4 other similar posts of artists in a Guwahati Medical College Hospital, which were filled up with, in which the incumbents who had held the posts were still working. Being aggrieved by the decision of the authorities to continue him to engage his services as an office assistant in the Department of Pulmonary Medicine, Guwahati Medical College, instead of permitting to render his services as an artist in the pathology department, Guwahati Medical College. The petitioner prepared a representation dated
23rd February 21.
Prepared a representation dated 16/9. This is 16/9, or you had prepared an earlier representation?
Yes, Lordship. Yes. Yes.
Yes, what?
Prior to joining that post, I prepared a representation, Lordship. But they did not consider.
Prepared a representation before the authorities, which came to be received on 23rd, 23/2/2021. So, learned counsel for the petitioner submits that this representation was submitted enclosing all relevant documents. So, this representation, however, was not disposed of by the respondent authority. Instead, on 24th of February 2021, petitioner stood released from the Department of Pulmonary Medicine and was placed under the disposal of the Director of Medical Education for engagement in other medical colleges in Assam. Stop. Where being aggrieved, he is filed. No, he thereafter prepared another representation dated 26/2/2021, highlighting, ventilating his grievances pursuant to the order of release issued dated 24th of February 2021. So, the the counsel for the petitioner submits that he being appointed as an artist pursuant to a proper selection, and there is no dispute with regard to his appointment and the services rendered. The impugned order dated 24th February 2021, releasing him from the Department of Pulmonary Medicine, Guwahati Medical College, to be placed at the disposal of the Director of Medical Education for engagement in any other medical college with immediate effect is arbitrary, and the same ought not to have been issued, and therefore the same needs to be interfered with, set aside, and quashed. The respondents have contested the case of the petitioner by filing a counter affidavit. In the counter affidavit, the averments made by the petitioner were not denied. At the time when the affidavit was being filed, the petitioner was still working under the Pulmonary Medicine Department, Guwahati Medical College, in view of the interim order passed by the court in the present petition. So, subsequently, a further additional affidavit was filed by the respondent authority to state that the post of artist held by the petitioner was not converted into office assistant, but due to shortage of manpower in the post of junior assistant and senior assistant, he was engaged as an office assistant in the Department of Pulmonary Medicine, Guwahati Medical College Hospital. Counsel for the parties have been heard, pleadings available on record and carefully read. After having noticed the averment made in the writ petition as well as in the affidavit in opposition, it is seen that there is no dispute that the petitioner was engaged as an artist, ID order dated 2/1/1996, and subsequent thereto, he had joined in the Department of Pathology, Guwahati Medical College, as in the post of an artist. ID his joining letter dated 2/1/1996. So, there is also no dispute that the petitioner had rendered services in the post of artist. So, during the COVID period, petitioner was engaged to work as a office assistant at the Department of Pulmonary Medicine, Guwahati Medical College, by the order dated 16th of September 2020. This order is a common order passed for several other employees, including that of the petitioner. So, pursuant to the order passed, he was released from the Department of Pathology for reporting in his new place of posting. Stop. The counsel for the petitioner has not been able to refer to any rules or notifications or office memorandum which which lay down the parameters or the job profile of an artist. So, the respondents also do not dispute the contention of the petitioners that he was appointed as an artist and presently engaged to work as an office assistant in the Department of Pulmonary Medicine. So, the petitioners have not been able to place before the court show that the post of artist is not a transferable post. So, the case which appears to have been projected before the High Court at the time when the writ petition was filed is that, notwithstanding the appointment of the petitioner as an artist, his engagement as an office assistant is an attempt by the authorities to convert his initial appointment as an artist to that of office assistant. So, however, in the face of the additional affidavit filed by the respondents on 20 February 2025, and in view of the averments made in para 2 within bracket Roman 2, that the post of the artist held by the petitioner has not been converted into office assistant, as was found mentioned in the order dated 21 21/11/2024. The court is of the view that that the apprehension expressed by the petitioner that his appointment to the petitioner has been sought to be reverted the post of junior assistant from the post of artist to which he was initially appointed is not cannot be accepted to be correct from the facts pleaded. So, there is a clear averment in the additional affidavit filed by the respondent authority that the petitioner is still holding the post of artist. So,
And drawing
by
his
the-
salary as an artist.
and drawing the salary as admissible under the provisions of law. The by the order impute in the present writ proceeding, which is by the order dated 24th of February 2021, petitioner was released from the post of he was released from the Department of Pulmonary Medicine and was placed under the disposal of the Director of Medical Education for engagement in other medical colleges. It is seen that pursuant to the services rendered by the petitioner as an office assistant in the Department of Pulmonary Medicine, Guwahati Medical College, he was released from services to be placed under the Director of the Medical Education for engagement in any other medical colleges. This order does not reflect that the petitioner is to be engaged or re-engaged as an office assistant. Stop. As mentioned here above, the petitioner has not been able to demonstrate that the post of an artist is not a transferable post, or that under the Directorate of Medical Education Assam, or that his services cannot be utilized under the Director of Medical Education Assam. Stop. It is also seen that the representations prepared by the petitioner has not been disposed of as submitted before this court. Stop. Under such circumstances, this court is of the view that the writ petition can be disposed of with a direction to the respondent authority to look into the grievances raised by the petitioner, and since the petitioner is engaged as an artist by his appointment order dated so and so, the petitioner should be permitted to work as an artist. Stop. However, in which department or in which college the petitioner is required to work, the same shall be subject to the respondent authority, provided the same is permissible under the provisions of law and the service rules. So, the representation stated to have been pending before the authority be disposed of within 60 days, within 30 days from the date of receipt of a certified copy of this order, and disposed of by speaking order within 30 days from the date of receipt of this order, and a copy thereof be served on the writ petitioner. Copy of the speaking order will be served on the writ petition. Stop. Till such an order is passed, the impugned order, the interim order passed by this court will continue to be in operation. So, with the above observation, writ petition stands disposed.
You will kindly record one thing. I submitted that the educational qualification for the post of artist is HSLC with degree or diploma in fine arts, Lordship. Whereas, Lordship, apparently in the post of junior assistant or senior office assistant post doesn't exist, Lordship. In their affidavit also, they have not justified that, Lordship. Either in junior assistant or senior assistant, the qualification.
Are you receiving your salary?
Lordship.
As an artist?
Yes, Lord. That's all, Lordship. But then the qualification is different, Lordship. That's what I was pointing out, Lordship.
You are right that you may not be getting job satisfaction.
Maybe, Lordship. But there exists vacancy.
Does it give you a right to be heard for the court? To that extent, unless you show, that the rules are very categorical.
I am just saying that Lordship may kindly record.
Why should we record anything which is not required to be recorded? For what purpose?
Lordship, just I want.
For what purpose?
So that
the authorities think that you are capable of working as an office assistant.
While disposing of the representation, Lordship, at least that point may be kept in mind.
We have said that they will look into your grievances as permissible under the provisions of law.
And one more thing.
You have not demonstrated that what is the job profile of an artist.
Lordship, I just say
maybe as on date your job has become redundant.
No, Lordship, because the advertisement is there, Lordship.
Maybe, once a post is created in a particular period of time, the necessity of continuing of that post over a period of time may have become redundant, but somebody may be working there. So therefore, the government desires to continue with that post, engaging the person somewhere, someplace.
This is an advertisement of November 24, Lord.
But what is your job profile? You as an artist, you can't say, you are saying that as an artist, I have to draw diagram. Of course, as an artist, that is what you have to do.
Specimens of those, Lordship.
And do what? Why should you draw diagram? For what purpose?
So that the students may learn, Lord. That much only. And one more thing, Lordship, they have just stated that there is no break in my service, Lordship. And one certificate was issued and I was agreed by that, Lordship. I apprehended that there was break, Lordship. Since they have stated there is
no break in service.
Lordship, that may be kindly recorded in the order also. Otherwise, that may create problem from.
Is there any order where they have said that there is a break in service?
One certificate was issued by them, Lordship. Here a break was shown.
Yes. Certificate where? Which page?
Lordship. Certificate is in affidavit in reply, Lordship. Paragraph 6, I have stated. Annexer 1 to that. Page 8. Affidavit in reply, Lord. There is an annexer, annex, Lordship, in that.
Page? Annexer?
Internal page is 8, Lordship.
8.
Yes, Lord. This is to certify that Sri hidden products son of source and so.
You're referring to the additional affidavit.
Affidavit in reply, Lordship.
Affidavit in reply. Yes.
Lord. This is certified that hidden products son of so and so has been working as artist Guwahati Medical College, Guwahati since 2nd January 1996 to 23 31/3/21 and 31/3/21 to till date. So in the period in between was not counted, Lord.
You have not challenged on that. Has your salary been deducted? Is there any
He said he did not receive the salary for that period, and a statement to that effect is also there, Lordship, in this affidavit.
You may not have reported for service.
No, Lordship. They say that, Lordship, that I am working against that post.
No, you are referring to the period in between.
Yes, Lord.
23/2 to
21.
31/3.
Yes.
Little more than a month.
Yes.
You may not have.
So they have clarified in their affidavit, additional affidavit in opposition.
Yes, we have stated
Where?
without any break since this appointment.
They added one more line. Further, it is seen that in the that by a certificate dated 26 March 2021. No. Sorry. Certificate dated 26/11/2021. Petitioner was shown to have been working as an artist in the Guwahati Medical College since 2nd January 1996 to 23/2/2021 and 31/3/2021 to the date of issuance of the certificate. So, the apprehension expressed by the petitioner that this certificate indicates a gap period which may result in a break in service, which may resultantly be construed to be a break in service, is also unfounded in view of the averments made in para 2 within bracket Roman 2 of the additional affidavit filed by the respondent number 3, whereby an averment is made that the post of the petitioner has not been converted. You are referring to this paragraph?
Yes, Lord.
Yeah. That the post of the petitioner, petitioner is holding, post of the artist that the petitioner is holding is not lying vacant, and is still holding the said post of artist without break in service, without break since his appointment.
Obliged.
Kindly peruse the order dated 21/1.
Yes.
I have received instructions that everything has been paid, nothing is due. Regarding the affidavit, nothing has been paid. Wait for time to bring on record.
Yes, Lordship, I have already submitted required information, but they are just randomly submitted that everything was paid. But against my submission, they could not reply to me anything specific. Already I have submitted, after this honorable court order, I already filed an application directly to the CGM HR of Numaligarh Refinery, but till that I did not get any response. I would like to also
furnish him.
He has been punished, that is what he's saying.
Nowhere they have given any details that they have, whatever I have claimed.
Let him file an affidavit as to what he claims has not been paid.
Lordship, I have already filed in my writ petition as well as in my subsequent affidavit. I already submitted. Lordship. They repeatedly just denied the issue and they randomly responded to the issue.
let them show that where they have responded to my submission with respect to my submission in the repetition. Let them show where they have replied to me.
What any?
They are just
file your affidavit.
Lordship, in numerous occasions, this honorable court repeatedly mentioned them that they have to file a separate reply against my claim. They could not submit anything, Lordship. Let them show that, Lordship, I have filed an application to the CGMHR to kindly pass an order to release those payment as by considering as ex parte, because they are repeatedly could not respond anything, Lordship. Not only this my claim, but also my repetition, they could not submit anything, Lordship, with specific details along with supporting authenticate document. Whatever they have submitted, just they are manipulating it. Lordship, another occasion, in 22nd of in 22nd of August 2024, when this honorable court continue hear my matter, then I submitted that everything they are submitting randomly. They manipulate their own document, own statement. There is a suppression of material and fact. There is a misrepresentation. They just misguide me throughout the disciplinary process, and even in this honorable court, they could not confirm anything. Against my submission, the Learned Council of Respondents 2 and 3 object to my submission and propose to submit a point of argument. But subsequently, after that, though the hearing could not be continued and deferred, but the Learned Council as well as the respondent could not submit a single point of argument, Lordship. It is a totally malified, and there is a completely, each and every document is unlawful, each and every document is unconstitutional. Each and every action as well as document were totally violating my fundamental rights as well as all the legal rights, Lordship. They could not confirm. They could not confirm a single CDR rule, Lordship. That this CDR rule they have when they issue an order, this CDR rule they have followed, or there is no any. They could not confirm any procedure. Not only respondent, the inquiry officer also suppressed the material and fact, and he himself, while he declared the inquiry as an ex parte, he himself manipulated his own document. He did not follow a single CDR rule. Where inquiry officer did not follow a single CDR rule. He has to submit me the daily order sheet immediately after the inquiry proceeding, but he did not submit it. And not the daily order sheet of the second proceeding, he did not declare it as an ex parte. But when I file a complaint to Vigilance Department about the corrupt, indiscipline, and financial anomalies, then they backdated. They issue a inquiry report by mentioning that the inquiry was conducted ex parte. The inquiry officer himself manipulated his own statement. In earlier occasion, he mentioned that if I did not appear the inquiry, then they will consider it as an ex parte. But after I appeared, I submitted written reply. Then when I submitted a complaint to the Vigilance Department about the corrupt, fraud, and indiscipline act, then they concluded the inquiry as an expert. And while the inquiry officer declared the inquiry as an ex parte, he himself manipulated his own document. Because in the second daily order sheet of the second inquiry proceeding was, there is nothing mentioned that the inquiry was completed as an ex parte. But in the inquiry report, he manipulated the second daily order sheet of the second inquiry and to declare the inquiry as an ex parte. And not only there is a manipulation or suppression of material fact, Lordship, the disciplinary authority who take the who issued the memorandum, he did not have any required rank and position to issue the memorandum of charges. And the appellate authority who took the authority as an appellate authority, he was never in the post of.
Where are your prayers?
Yes, sir.
Which volume?
Can I refer to the volume 7, Lordship? Recently, I submitted a written argument.
Volume 7. So I want to see your writ petition.
Volume 1, volume 1.
Five. You did not file an appeal. Appellate forum.
Lordship, I filed an appeal, but I filed an appeal to the managing director. But in the meantime, the managing director was retired. Then the respondent 4, who was in the director technical as well as additional charge of MD, but he took the appellate authority illegally, because as per CTA rule, my appeal is required to be handled by MD only. And if in absence of MD, then my appeal is required to be sent to the higher authority. That is, the chairman of NRL is required to be handled by. But by doing coercion, undue influence, and by misrepresenting on the issue, they call me and they threaten me that if you are approaching the honorable court, it will take 5 years to settle your case. Then they misguide me by submitting an application. Everything was misguided me by doing coercion as well as by undue influence. Then I submitted that application. With the help of that application, the respondent 4 handled my appeal, though he was not in the post and rank and post of managing director. There is a lot of unlawful act during the disciplinary process. And in the affidavit in operation, they could not confirm anything. They just manipulate their own document. They give contradictory statement as well as false statement. I have listed the details of false document, false statement as well as contradictory statement by mentioning the page number also, Lordship. It is a totally a fake, Lordship, fake termination, Lordship, just to suppress the corruption as well as indiscipline and financial anomalies that I raised during the before the discipline. This is a totally revenge action, Lordship. I file a whistleblower complaint also, but another cases, when I file a whistleblower case, complaint, that was responded. But this where I have mentioned the corrupt, indiscipline and financial anomalies, that was never responded. That after filing the whistleblower complaint, they illegally appointed the inquiry officer. They violate all the company security rules. They took the illegal rights of disciplinary authority, as well as they manipulate all the document. Accordingly, they to take revenge on me, they actually impose this penalty of Lordship, removal from service, so that I cannot pursue my complaint further, Lordship.
What is the show cause?
It's 50. The process of preparing a list of dates. I was under the impression that the matter may not be taken up because he was supposed to file certain documents. He has not filed it.
No, Lordship, that is the totally
Let me submit.
sorry.
as reflected in the last order, madam. Was supposed to file certain documents, and the writ petition itself has become so voluminous, madam. It is running up to 1100, 1200 pages.
May I please?
1500 pages.
May I please?
Don't overlap. He is submitting something. Wait for your turn. Don't get impatient. 503.
50. First focus, I'm sorry, madam, it is 436. 503 is the charge sheet.
So that is what I want.
The memorandum of charge is 50.
503. So there are two charges, essentially. Just one charge divided into. You did not join in the place of both. That's the charge.
May I please? Lordship, first of all, this so-called the penalty order which was issued by the respondent himself acknowledged that he was issued this so-called notice without having any order.
We will come to that later. We are asking you what is the what are the charges against you?
Yes, so there is only two charges. One is that I did not report to duty and I did not apply leave. But they contradict their own allegation in the later stage in the memorandum of charge.
Where is the memorandum of charge?
Yes, Lordship. And these so-called notice, Lordship, is totally unlawful because they quoted arbitrarily a clause 27C which was never existed, and they suppress. They use this 27C, the old one, to suppress the issue. They did not mention anything specifically. Can you refer the first, second, third, fourth para? In this context, we draw your
fourth para, page number what?
436 so-called notice.
Huh?
436 so-called notice.
436.
So-called notice.
Yes.
Lordship, the fourth para, it said that in this context, we draw your attention to clause 27C. There is no clause 27C at the time of dated 02/12/2020 because it was already amended. To use this para against me, they suppress the issue by not mentioning anything specifically because they have to mention either CTA rule 1995 or subsequent amendment. But they did not mention anything. Thus, they randomly mentioned CTA clause applicable to you. But after that, I repeatedly placed query also. They never responded. And Lordship, the most important thing is, Lordship, while they issued this focus notice by mentioning a very fast line, this is a reference to the office order personnel 60 C confidential annexure 2 dated 27 August 2020. There is no such order exists on that day because they just use this line to suppress the violation of transfer order. The transfer order was violated by respondent 6 by duly in consultation with HR. To suppress the issue, they just falsely mentioned this line. Actually, the issue arises because of transfer order was violated by them only, Lordship.
What violation?
In the transfer order, it was mentioned that I have to report to the new place of working within a period of 60 days by duty handing over my job. But within period of 60 days, before 60 days, prior to 60 days, 6 days joining leave is there, Lordship. And prior to 60 days, the respondent 6, who is my reporting authority, he has to advise me for handing over my job to by mentioning one or two officers. Okay, at that time, I was handling around job loop of two number, more than 2 numbers of officer. So he has to mention the name of the officer to whom I have to hand over my job. But he did not mention to, they just create an issue against me so that after joining in new place, I cannot raise their indiscipline, fraud and corrupt act. So that he himself violated the transfer order and try to put an allegation upon me that I violated the transfer order. So therefore, they initially did not mention anything that I violated the transfer order. Even in the memorandum of charges and subsequent penalty order also, they did not mention. In the affidavit in opposition only, in this honorable court, they mentioned that I have violated the transfer order. But if I violated the transfer order, what they are doing, Lordship? They have to issue a show cause notice immediately after 60 days. Why they are entertaining me with salaries and all those dues? Because the transfer order was violated by them, that is why they cannot neither CMNRT, though they mention that they send document to CMNRT, but while they submitting communication to me, then they mention random data. And my leave application is required to be handled by chairman of NRL. Neither chairman of NRL, neither CMNRT can handle my leave application because before handling my leave application, either CMNMT or chairman NRL has to clarify, get clarification that who has violated the transfer order. To suppress the issue, they actually randomly.
Where is what violation of transfer order are you referring? Where is the transfer order?
Yes.
Hmm?
345. He has employed only part of the transfer order. The routine transfer order of around 45 officers. This case is at page 346, serial number 45.
Where is the illegality?
It is mentioned that, however, in case of transfer involving change of location, the time is allowed shall be 60
You're
days.
reading from which page?
345 Lord.
345.
Para second Lord.
Para?
Second.
Huh.
However, in case of transfer involving change of location, the time allowed shall be 60 days as per prevailing rule. For interstate international transfer, separate advice for such movement will be given to the respective staff, and they have to move within 60 days of such intimation. So there is another instruction on the last line. All officer on transfer need to submit copy of handing over, taking over note to HR department along with their joining report. So that's it. If I have to report the before 60 days, then I have to release from my job before 60 days. But they did not release me before 60 days.
No, not before 60 days. You have 60 days.
Yes, Lord.
You will have 60 days to go and join from the date of the order of transfer.
Yes, Lord.
You are not supposed to be released before 60 days. You have 60 days time to go and join.
Before 60, I have to allow to 60
Within
days.
60 days. Within 60 days of such intimation.
60 days I have to join there. That is, I have to join. The transfer order was published on 5th June 2020. So as per this transfer order, I have to join at a new location on 03/08/2020. But on 29/07/2020, the respondent himself called me over phone and asked me to submit an application against the transfer order. Then I consider I have already submitted it along with my read petition, where I also mentioned that it was submitted as per your instruction only. Then he on 04/08/2020, in the second half I submitted that application. If as transfer order was, I have violated the transfer order, I have to join duty at the new place within the period of 60 days. Then there is no need to wait for getting an application on 04/08/2020. And if they mention for the first time in this honorable court in a affidavit in operation only, they mention, though I repeatedly placed query during the disciplinary, that they did not mention anything. For the first time in this honorable court in the affidavit of opposition, they mentioned that without any release order, it is my duty to join there. Without any instruction to handing over job, it was my duty to handing over job to any kind of officer. But if it is my duty, then why they have releases me on 82 days from the transfer order? Why they have and another officer asked me to hand over job to another officer? But if handing over of duty is my sole responsibility without any instruction, then why they have communicated me on the 82 days to hand over job to another officer? But they just suddenly release me so that I cannot take leave with prior permission. And they can raise issue. They already aware that I have some medical issue. So I would like to take a leave. Therefore, to restricted me to take leave, they suddenly release me by violating the transfer order.
Yeah.
The main issue that they themselves violated the transfer order. That is why they could not they could not address my leave application. That is why they, since the violation of the transfer order was done by respondent 6 and duly consultation with HR, so they try to put allegation on me to suppress their issue. And kindly, Lordship, kindly refer to the page 571.
One minute. You have prepared a list of dates.
Yes, sir.
You have prepared.
List of this maybe mentioned in my repetition.
No, not that. Just give us a gist of the relevant dates. What about the respondents?
There are, now I find there are some mistakes.
Hmm.
According to us, my lord, it is a pure and simple case of not abiding by the transfer order. Then he refused to participate in the disciplinary proceeding. Neither the transfer order nor the disciplinary proceedings were.
You did not participate in the disciplinary
Lordship, this is a false allegation. As per CTA rule, they did not follow a single CTA rule. I mentioned that, give me some clarification. Though the inquiry officer himself manipulated all the issue, my submission was also manipulated. And the inquiry officer who...
Why did you wait for the order to be passed? Why did you not agitate this issue? Did you come before the court earlier?
No, Lordship, because there is a misrepresentation, Lordship. There is a suppression of material and facts.
I know, there is a... Let us take your word that there is a misrepresentation. Why did you sit over it?
No, they were
until the order of discharge was passed.
They were supposed to give me clarification, Lordship.
They were supposed to, they did not give. What have you done after that?
No, they initiate the process for voluntary abandonment of company service. But Lordship, there is no any such allegation they impose against me to issue a voluntary abandon of company service. If I did not participate in the inquiry process or did not reply to them, they easily issue a voluntary abandonment of company service. And
They issue a what? Voluntary?
Abandon of company service. Because there is no allegation.
He does not join, it amounts to voluntary abandonment. That was because he did not join.
Lordship,
that was the charge.
No, Lordship, this is a totally false representation, Lordship. If I did not join, then immediately 21 days they can issue a voluntary abandon of company service. Then why they have entertained me with salaries and all those dues, Lordship, for a period of 6 months, and even after that, Lordship, if I was absent for a period of 21 days, which is a very serious and grave in nature, they themselves mentioned that. If this is a very serious and grave in nature, then why they entertain me for a period of 6 months, Lordship? And even immediately after 21 days, they have to issue a voluntary abandon of company service. And not only 21 days.
We'll hear you. Let us fix a date.
Lordship,
complete your list of dates.
Lordship, kindly hear my matter as a part head, because for last 1 year, Lordship, 1 year, Lordship, I have been suffering, and last 5 years there is an urgency. This honorable court already considered my matter urgency 1 year before, Lordship.
We'll hear you in April. 8th of April. 8th of April.
8th of April.
8th of April may be declared as a motion.
Why is that?
Before the BU ticket.
Lordship, I have been suffering for a period of 5 years. Okay? I have some serious...
When were you terminated?
Lordship?
When were you terminated?
On 8th October 2021. But from 2020,
there are no dues receivable by you.
I did not receive the due. They randomly just deducted the issue, Lordship. I have already submitted an application, Lordship. They could not confirm anything, Lordship. Even in this petition, I already submitted an application by mentioning the honorable court order to CJM HR, Lordship. If this honorable court allow me, I would like to submit it, Lordship. Can we pass an order to at least issue this pending dues, because they could not confirm anything, Lordship. They not only...
let him give me a copy of what he has submitted. I'll get my instructions. My instructions are clear that everything has been paid.
No, Lordship, this is a totally random statement given from last 2 years, Lordship.
You serve a copy on the council.
Because in earlier occasion, this honorable court advised me not to serve anything without the leave of this honorable court.
We are permitting you to do it.
Yes, Lordship.
You serve him a copy.
Yes, Lordship.
Let him get these instructions if any dues are payable. If they're payable, you release it to him, Mr. Deka.
Definitely, my lord.
Yes. You serve a copy.
Lordship, I have been suffering for a period of 5 years. Can you consider my matter as a part, Lordship? Because this honorable court already consider my matter.
Why do you want the matter to be part heard? We'll hear you. We have stated we'll hear you.
Because, Lordship,
How soon can you get the instructions, Mr. Deka?
Within a week times, week's time, I
Right, then
can
come back after a week.
Lordship, earlier in 6 occasions, Learned Council of Respondent 2-3 refuses to do the hearing, Lordship, continuously, Lordship, by citing different issues, Lordship. Sometimes he mentioned that he has some problem in his leg. Sometimes he mentioned that he has forget to.
personal, madam.
No, not only personal, because
We are fixing it on 27th, you get the instructions. 27th of March. You serve him a copy? Heard Mr. Avinash Bora, petitioner in person, and Mr. N. Deka, Learned Counsel appearing for the respondents 2 and 3. Mr. N. K. Sharma for 4, 5, and 6. This, as per the earlier order, it is seen that certain dues claimed by the petitioner, which the petitioner claims had not been released to him as per his dues. Stop. Mr. Deka, on the other hand, submits that the instructions he received from the company are that no dues are payable to the petitioner. Stop. Such submission is disputed by the petitioner in person. Stop. Considering that the petitioner in person submits that certain dues, notwithstanding his claims made in the writ petition, are still payable by the respondent company, we permit the petitioner in person to serve a copy of the how have you raised the dues? How have you brought it? By way of a representation?
Yes, but I have filed already
A copy of the representation filed before the company claiming the dues stated to have been payable to him. Stop. We permit the copy of this representation to be served on the counsel for the NRL as well as the counsel for respondent number 4, 5, and 6. And the respective respondent counsels will, the counsel for the NRL will apprise the court with regard to the claims of such dues made by the petitioner in person on the next date fixed. As agreed to, let the matter be listed on 27th of March. You serve him a copy right now.
Yes, sir.
You have a copy?
Yes, sir.
Right. Mr. Bora has submitted a copy of the representation reflecting his dues. Serve him now to Mr. Deka in court. Stop. He is also permitted to serve a copy of the same by way of the email to the respective counsels. Please share your official emails, whatever you have, you serve a copy. Stop. Let the matter be listed again on 27th as directed. 27